Here, your first examining business of the appellate division court here. Give your attendance and you shall be heard. Good afternoon, everyone. Please be seated. Welcome to the Appellate Division First Department. We have oral arguments for today, May 5. So we have more than 7 hours of argument time requested. So please, I'm going to ask everyone, please just ask for the time that you actually need in order to get out the salient points of your arguments. People v. Julio Pena. 4, 1, and 3. Wells Fargo v. Wythe. Thank you. That matter is submitted. By the way, Justice Rodriguez is recused on that matter. Velo v. Verizon, New York. 414. McNeil v. Gerwitz, or Giewitz. That matter is submitted. People v. Pedraza. 5, 2, and 5. So myself and Justice Pitt Burke are recused on that matter. Justice Schulman will be vouched in on that matter, and that case will be called first. New York Concrete v. Contract Dispute Resolution.
Respondent request 5, Your Honor.
5, 2, and 5. Fala v. Auxiliary of Elmhurst Hospital. Okay, I'm sorry, you want to rest on your brief?
Yes, I didn't a lot of time in my brief.
Matter submitted. LeBron v. Bronx Heights Beulah. Matter is submitted. People v. Jamel Ingram.
Didn't you skip 71st Street?
Did I skip one? I'm sorry, I skipped 71st Street v. Franco. Apologies. 5, 2, and 5. People v. Jamel Ingram. 5, 2, and 5. Still Point Meadows, PH 62 v. Residential Board of Managers. 5, 2, and 5. People v. DeShante Page. 5, 2, and 5. Baraldi v. 900 3rd Avenue. 5, 1, and 5. Oh, I'm sorry, who do you represent? 900? Okay. 5, 1, 5, and 3. Francis v. NYSR SARC, Inc.
Your Honor, respond.
Listening.
Respond due to my non-appearance of the question.
You wish to submit? Matter is submitted. Sherry v. Hogan.
I respond request 6.
6, 2, and 6. People v. Michael Brooks.
Appellate request 5 and 2, Your Honor.
5 or 2? You want 5? 5, 2, and 5. Thomas Realty v. Chiliotz.
Yes, Your Honor. Appellate request 5 and 2.
Who do you represent?
Individual respondents, 3 minutes.
5, 2, 3, and 3. First case for argument is People v. Pedraza.
You may begin.
Good afternoon. May it please the court, Gabriela Agranat-Getz on behalf of appellant Eugenia Pedraza. All Ms. Pedraza had to show here to warrant a hearing on Lafleur prejudice is a reasonable possibility that the prosecution would have offered and that she would have accepted a more favorable plea. And based on,
Is it just that it's more favorable, or is it that it's favorable with regards to immigration consequences?
So-
There's a vast difference.
well, I'm glad you asked. For Ms. Pedraza, specifically, a more favorable plea does mean an immigration safer plea, but it is within the larger context of a more favorable plea. And based on all the factual allegations that she presented in her moving papers, the motion court actually found just that, found that there was a possibility that the prosecution would have offered and she would have accepted specifically an immigration safer plea here. The issue is that the motion court denied her motion by applying a higher and incorrect standard of reasonable probability, which is the standard, the only standard she needs to prevail after a hearing. But in order to warrant a hearing, which is
What's the evidence of the suggestion that would lead one to believe that the defendant, that there was a possibility that she was going to receive an immigration-friendly sentence or disposition?
so first, Your Honor, in the record itself, we can see that pre-trial, Ms. Pedraza was offered a sentence of 3.5 years.
But it doesn't say what it was for.
That's right, and that would be a question for a hearing, which is one of the many reasons why a hearing is warranted here. But what we do
Be that as it
know,
may, she turned that down repeatedly, correct?
she did, Your Honor. However, she turned it down without knowing the full consequences of what that plea offer would entail, and without knowing the full consequences of what conviction after trial would entail. She was clearly charged with what are considered aggravated felonies under the immigration law, and conviction after trial would.
Can you address this people's argument that Padilla is not retroactive?
Sure, but first, I just want to make clear that the motion court here did not find, the motion court here found two specific claims, or decided on two specific claims. One on Padilla, which was not actually a claim that Ms. Pedraza raised, and the other was under Lafleur. Under the motion court's decision on Ms. Pedraza's Lafleur claim, the motion court actually never stated or argued or decided that Lafleur was not retroactive. So under LaFontaine, this court wouldn't be able to affirm the motion court's decision on that basis. I just want to go back to the 3.5 years question, where Your Honor asked about the reasonable possibility of the 3.5 years. So yes, we didn't know the actual charge here. That's one of the many reasons we.
Counsel, in light of the charges here, I mean, it's serious, right? It's kidnapping, murder, attempted murder, arson. Can we even get to an immigration-safe plea from those charges?
Yes, and actually Ms. Pedraza's
How?
co-defendant was offered just that, attempted kidnapping in the second degree, which is precisely the offer that was made to Ms. Pedraza's co-defendant, accepted by Ms. Pedraza's co-defendant prior to her going to trial, which shows that there is an indication that the prosecution could have offered Ms. Pedraza that very same plea, which again is why we need a hearing here, right? To determine the actual reasonable probability of whether that plea would have been offered would be determined at a hearing. But certainly knowing she had 3.5-year sentence option, knowing her co-defendant was offered a plea that would have been more favorable, immigration safer to her, knowing those factors, that's enough to warrant a hearing. And this court has shown repeatedly in Guzman Caba, in George, in Richards, that these are factors that are all that we need to get a hearing.
But there was no evidence in the record to support that the people would be offering a immigration plea favorable,
The evidence,
immigration
Safe plea.
Safe.
favorable hearing, favorable.
Understood. The evidence is directly in the record. First being that we know she was offered a 3.5-year sentence. That's in the trial court.
But the 3.5 years, that's misleading, right? Because while that is favorable, it's not immigration. We don't know if it's immigration safe.
Well, that could be determined at a hearing. And just to add,
You may finish your answer.
Thank you, Your Honor. Just to add to that, so that would, one, be determined at a hearing, and the other thing we can look to are what are the actual charges here. And there were only limited possibilities that could be offered to Ms. Pedraza to fit the procedural statutory limitations of plea offers and that were immigration safer. And one of those was offered to her co-defendant, certainly enough for reasonable possibility. Thank you.
Good afternoon, Your Honors. My name is Brian Wattoon. I represent the respondent. The issue of what offer Ms. Pedraza may or may not have received is really the secondary issue here. The first issue is that what she's alleging is classic Padilla error. She's trying to dress it up by any other name because there's binding case law that reflects Padilla is not retroactive. But when it comes down to it, this is a classic Padilla claim. In fact, counsel has said that that Ms. Pedraza received the exact offer, the exact immigration safer offer of attempted second degree kidnapping that she now says she would have accepted. That's Padilla error. If she says she would have accepted it, if only she had been advised of the immigration consequences of accepting that plea versus proceeding to trial, that's exactly what Padilla covered. That's exactly what Chaidez
And it's undisputed that Padilla was decided in 2010.
Yeah.
And the finality, the conviction was 2002, the finality with the Court of Appeals, et cetera, is 2006. So that's really out the window.
Exactly.
But what was more interesting is that in support of the motion below, she claimed that Mr. Lee, her prior counsel, failed to really communicate with her, spend quality time with her, have an interpreter there because she only spoke Spanish, and he allegedly spoke English and Italian, et cetera. And she swore to those allegations below, but that was inconsistent with the finding by this court that confirmed that that's just not true.
Yeah, exactly. That was all previously litigated. This court affirmed it on direct appeal of the first 440 motion. By the way, that first 440 motion post-dated her notice of removal from Immigration and Naturalization Services by a year. So this, immigration consequences would have been no surprise to her back then too, yet she didn't raise this current 440-10 motion until 15 years after that, 20 years after the original conviction. So Justice Rosado, I know we've had a couple more recusals today. It feels like half the First Department was involved in this case at some point at the trial level. But Justice Rosado, in this most recent 440-10, aptly noted that this court had previously affirmed the prior 440 court's finding of effective assistance of counsel, and that this is a Padilla claim, and that Padilla doesn't apply retroactively. If there are no additional questions, I ask you to affirm.
Thank you.
Two quick points. First, to emphasize, reiterate, respond to the respondent, Ms. Pedraza did not make a Padilla claim, and the court, the motion court, was very clear in looking at Ms. Pedraza's Lafler claim that the motion court took the deficient performance prong, the duty of defense counsel to negotiate with immigration mind, took that as a given. The motion court never denied on that basis, and under LaFontaine, this court could not affirm on a basis that the court below never decided. Secondly, and apart from that, just multiple Second Department and New York cases have found a duty to negotiate for an immigration safer plea to be retroactive pre-Padilla. So it is separate and apart from Padilla, just like how the motion court found. Secondly, to Your Honor's question, or raising Ms. Pedraza's credibility or affirmation in a prior 440, that is, again, precisely why we need a hearing here. In this 440, Ms. Pedraza submitted an affirmation to the court. She submitted a pre-pleading memorandum that supports that affirmation, showing her strong incentives to stay in this country, showing why deportation would have been devastating for her, why banishment from her country would have been devastating. If there are questions as to her credibility, as to those strong incentives, that would be a question to be resolved at a hearing. But she certainly submitted enough to warrant a hearing. And again, the same strong incentives that this court has found in other cases and has remanded back to the trial court for a hearing. And if there are no further questions,
Any other questions? Thank you. Thank you both.
I would ask that that the case be remanded for a 440 hearing.
Thank you.
People v. Julio Pena.
Good afternoon. I'm Danielle Bernstein from the Legal Aid Society on behalf of Julio Pena. Your Honors, the court below deviated from its obligations fundamentally by abandoning its role as a neutral arbiter at sentencing.
By what? I'm sorry.
Abandoning its role as a neutral arbiter at sentencing.
How is that?
It made
It was a negotiated plea, and the understanding that the defendant would plead guilty and would receive 21 years. Is that correct?
Your Honor, courts are required to
No, but
say-
I'm sorry.
Yes, that's correct.
Okay. And so did the judge deviate in any way from that negotiated plea?
That's not the measure of whether they remain neutral, Your Honor, which is a foundational
Well, you stated that he was not neutral. So meaning that somehow he was biased or he did something to the detriment of the defendant. But my question is, given the fact that he did not, that he accepted the plea, which was an illegal plea, but nobody is saying anything about that. He accepted the plea. He did not reject the plea. How, therefore, was he not neutral, and how did his behavior in any way, how was that behavior in any way detrimental to your client?
So first of all, Your Honor, there are many times where courts intervene despite there being a negotiated plea to result in a lesser sentence than what's been negotiated.
He wanted a higher sentence. He
That's
thought
my
that
point, Your Honor, that the judge wanted a higher sentence.
But he agreed to the lesser sentence. That's what I'm not understanding.
If I may read from what the court said, Your Honor.
I know what he said. He said he's getting away with murder. This is sickening to me. That's what he said.
Well, it's about 5
but
paragraphs of
again,
that.
regardless of that, he still agreed to the people's offer and the acceptance by the defendant of the 21 years.
The point of including this, Your Honor, is that it requires this court to look at this sentence with more care than in other cases where we can trust that the judge approached it neutrally. We're not asking the court to make a legal ruling about the judge's behavior. The point of this is to say that unlike in other cases where, of course, the court's review of the mitigation stands no matter what, this is a case that requires special attention because it's clear that this court did not evaluate the mitigation.
Should this have been consecutive, these sentences?
That's not.
That's why I said it was illegal. I mean, it was illegal because let's get the two charges. One was the attempted murder, and the other one was murder, manslaughter or murder?
It's attempted murder and first-degree manslaughter.
Attempted murder and manslaughter. So the attempted murder was where the defendant shot an individual, and I guess he shot him to the middle of the body, to the abdomen, yes? The murder was he shot an individual, I don't remember how many times, to the back of his head, I think it was twice, and killed him, yes?
We're not contesting the court's finding on the record.
So why would 21 years not be a proper sentence, given the fact that he killed one person by shooting him in the back of the head, and the other individual tried to kill that individual?
And I would just add that the second incident, I believe he was out on bail when that happened.
Yes, he was out on bail, and that goes to my colleague's question in the fact that it should have been consecutive. Under the statute, it should have been consecutive and not concurrent.
Well, the court made a finding on the record that allowed it to be concurrent, and, you know,
Which, again, that finding,
So then doesn't that kind of fly, or maybe lessen your argument? Because in order to make that finding, there has to be some presence of mitigation, right? And so if the court is finding mitigation so as to not have this consecutive time, how so is he then not a neutral arbiter?
so a couple of things, Your Honor. First of all, the court did that kicking and screaming, right? I mean, we see
He
that.
still did it.
but he still did it.
Please let me, I would love to answer.
I'm
the
sorry,
question.
go ahead.
I think, you know, the issue here on the first charge, the attempted murder, you know, I actually think the deal here speaks to the difficulty the prosecution had in bringing that case, because the client here actually took that plea over defense counsel's advice in light of the lack of evidence on the attempted murder charge. So I think the reason the prosecution agreed to that concurrent time is because that was a weak case. Now, on the actual mitigation, I do want to mention that there are many cases with these kinds of charges where people get less than 2 decades in prison. And the reasons here that Mr. Pena falls within that category primarily are the remorse he showed and his family and community ties that will help him reenter the
He
community.
shot the man twice to the back of the head. You have time on rebuttal.
Good afternoon, Emily Aldridge for the People. Initially, the claim is foreclosed by the appeal waiver, but as this court has indicated, yes, he received this concurrent sentence. Nothing the court did in any way raise the sentence. Certainly, the argument is not that the court should have given less than the negotiated sentence. In no way did Judge Fabrizio say anything about the 21 years. He took issue with the concurrent nature of the sentence.
Could he have rejected the 21 years?
Absolutely. I've actually handled a case where he did precisely that, where he rejected the,
In terms of finding mitigation, it seems to me that the only mitigation that was found, and it's not really mitigation, is that the people lost their victim on the attempted murder case.
he was somebody who was never, he was shot in the groin. He sustained injuries to his genitalia. It's not surprising that he was not willing to testify regarding the extent
That's not
of his genital
mitigation.
injuries.
That's a proof problem for the people.
Exactly. But there were, we made the record that we were prepared to go forward based on the evidence. There was a photo array with this. He took the plea right after the photo array was shown. There was cell phone pings to put him in the area. And so certainly could have gone forward, but chose to allow this blanket offer. The mitigation arguments, and I agree with Your Honor, is a bit questionable. It was regarding where he aimed. He was in close proximity and he aimed in his groin. And Judge Fabrizio was not a fan of that argument. I believe he said something along that, oh, I get it.
What about his comments, though, on the record? I mean, you're getting away with murder.
It sickens me.
He did go along with it, and the truth of the matter is he is serving 0 additional time for the attempted murder. And again, he took issue not with the amount of time he's getting on this murder, where, as Your Honor indicated, he shot someone in the back of the head while he was after he made bail on the attempted murder. Here, he was only taking issue with the fact that it was concurrent. And if there are no further questions, I ask that you affirm.
Separately from the court's behavior, Your Honors, I would like to speak a little bit about the mitigation that we can talk about here. And, it is a thin record, unfortunately, but what we do have in this record is a showing of remorse by Mr. Pena, surrendering himself on the first case, and at sentencing, apologizing to the family of the victim in the second case quite profusely. And I do think that is an important consideration in terms of what the likelihood of recidivism is here, which is an important consideration for whether someone should spend 21 years in a custodial facility. He also is the financial breadwinner for his family. His kids were 4 and 13 at the time of these offenses, and they'll be 34 and 25 when he gets out. And the lack of financial support over that 21 years is really significant. I mean,
And all of this goes to your interest of justice argument?
Yes, Your Honor. And there are many cases that we cited in our brief where this court has considered those factors in reducing a sentence. We're not asking to go somewhere crazy here, right? We're not saying go to the minimum or something like that. 2 or 3 years off the top of 21 would at least get him closer in time to supporting his family, re-entering the community, and the likelihood of that having an effect on his chances of recidivism is exceedingly low. And so we think that would be an appropriate reduction here. And just finally, even where there are negotiated plea deals, courts do play an essential role in preventing injustice. Every defendant deserves a neutral arbiter, and Mr. Pena did not get that. So we do ask that the court closely review this. Thank you.
Thank you. Are the students from Baruch? Is that where you guys are from? Welcome. I hope you enjoy your time here with us. The next case is Wells Fargo v. Wyeth. Justice Rodriguez is disqualified on this matter. I'm sorry? Oh, it was submitted. Thank you. Never mind. Sit back down. Never mind. Belu versus Verizon. Sorry about that. Yes.
Good afternoon, Your Honor. May it please the court, Sean Hutchinson from Cipriani and Werner for defendant appellant Verizon New York Incorporated. The court below erred because it wrongly concluded that defendant did not establish a question of fact to preclude summary judgment on plaintiff's labor law 241 claim.
As I understand it, your question of fact is that there are two different versions of the accident. Is that right?
Correct, Your Honor.
So it seems the plaintiff respondent argues that under both theories, under either version of it, he's still entitled to recovery. So could you discuss the two theories and why he's not entitled to recovery under either?
Of course, Your Honor. So plaintiff's theory is that the backhoe bucket was hoisting up a piece of the concrete curb in addition to the asphalt surface of the roadway that was being excavated, and that the concrete curb cracked and fell off of, and fell out of the bucket and onto him. And
So if that was if that's what ultimately was found to have happened, why wouldn't he be entitled to recovery under the labor law?
because there is a second version of the accident, Your Honor, based on
Okay, so
eyewitness-
you agree that under the first version, he'd be entitled to recovery?
Possibly, Your Honor, yes,
But
probably.
in order for the two versions to make a difference, they would have to have a different outcome.
Yes.
So under the first version, do you agree that he would be entitled to recovery or not?
I would say more than likely, yes. But there's a second version
Yes.
of the accident, which is that the concrete curb overlay was still attached, was supposed to be attached and remained attached to the sidewalk that was adjacent to the roadway that was being excavated. And our first theory, our first argument is that plaintiff, who was the pitman and foreman on the project, was responsible for using available wooden braces.
But how would,
Brace.
but would it would only be appropriate for him to have put braces down if this accident was foreseeable. And was it foreseeable that the part of the concrete would break off?
Well, there's, in the affidavit from defendant's owner, it was stated that a brace is always supposed to use when there is a concrete curb overlay. Because a concrete curb overlay is
The
different.
defendant owner was there, correct?
Excuse me?
The defendant owner was there, right?
The defendant owner, but he was not actively supervising this work as it was taking place. He was
He
not
was
an eyewitness.
engaging in the work.
He was not. No, he was not taking place. He was not present at this specific location observing the work as it was performed. He was at the site, but not there. There's an affidavit also from the operator of the backhoe, who was the eyewitness to the accident. But Barada, who is the owner, he testified that that a brace is always supposed to be used when there's a concrete curb overlay. But even if there's a question about whether or not it was foreseeable or there was excavation taking place in that specific location that rendered it difficult to use that brace at that moment, that would still result in a question of fact. Because under a very recent case from the First Department, Veloso, which was handed down, I believe, on April 9th, the court, which was a First Department case, the court there concluded that a trench that was actively being excavated, wherein a very large portion of the trench that was deeper than this trench fell and struck the plaintiff.
Counsel, I want to clarify something. Jason Barada, which was the plaintiff's supervisor and co-owner of Granite, he was there using a backhoe to backfill the trench that day, correct?
No, it was Castellano, Your Honor, who was using the backhoe. Michael Castellano.
There weren't two people, Castellano and Jason Barada, using backhoe
There was a
that day?
separate. There was another backhoe that was being used somewhere else on the project site. That one might have been operated at that time by Barada, but the one that we're talking about now that was involved in the
What I'm trying to
occurrences-
get at, was Jason Barada at the site?
Yes, he was at the site.
But you're claiming although he was at the site, he was not at the this particular site where the incident occurred.
He
He was at the location, but he was not present when this
correct.
occurred.
That
You know how far he was from the incident?
I do not know, Your Honor.
And what was the case that you cited?
Veloso,
Did you spell it?
yes, it is VELOSO, v. City of New York, 2026, NY Slip Op 02167. And that was from April 9th.
Thank you.
Good afternoon, Your Honors. Lori Parkman for Plaintiff Respondent.
So plaintiff was the pitman and as well as the foreman on this job, is that correct?
Yes,
And as the foreman, he was responsible for making sure that there was bracing for these trenches?
I don't know if he was solely responsible. Defendant argues in order to try to create an issue of fact that plaintiff was the sole proximate cause and recalcitrant.
Right, so my question is, so he, as foreman, as argued by the defendants, he knew or should have known, right, that there should have been bracing, and there was no bracing, and he would have been responsible for the bracing as foreman.
Right, Your Honor, that argument, it does not apply the correct standard. Cases from this court are clear that to raise an issue of fact as that a worker was recalcitrant, the worker would have had to deliberately refuse to obey a direct and immediate instruction.
But he's the individual who would be giving the instruction, right? So because he did not, the argument I assume is that because he did not use the bracing, although he had knowledge that he was supposed to use the bracing, that therefore he would be a recalcitrant worker.
If you look at the affidavit of Barada, he gives no evidence whatsoever that plaintiff was instructed, which is the standard of this court. And
What import should we give to the fact that he did brace certain areas of the trench?
that goes to cases cited in our brief about the exercise of discretion is not enough. You have to disobey an instruction. And here Beretta didn't even say that there was a general instruction, not immediate, which is required. They just say that says that plaintiff should have known. Defendant can't cite even one case where there was no immediate instruction, but the plaintiff was found to be sole proximate cause because they should have known. That's not the standard for a recalcitrant worker. And the cases are legion from this court. I cite you to Vitucci from 2022, Lamache from 2023. That was a quote from Vitucci that in order to raise an issue of fact, the worker had to deliberately refuse to obey a direct and immediate instruction. There's just simply no evidence of that. A defendant can't shift the burden and the duty to the worker.
So in Anderson v. MSG Holdings from this department in 2017, apparently we stated that the recalcitrant worker defense did not apply where there is no evidence that the plaintiff was ever instructed or knew how to use. So here, as the plaintiff had previously used and therefore knew how to use it, why would the recalcitrant worker defense not apply?
Your Honor, I read that quote as having two separate parts. He was never instructed or he knew how to use. Those are. But
Well, as my colleague stated, there was testimony or evidence in the record that he had previously used the bracing, and that in fact he had used the bracing for another section of the trench, right?
Right, and that goes into the exercise of discretion cases that we cite, where they're trying to say plaintiff had the discretion to use these when he thought it was necessary and not use it if he didn't think it was necessary. It was up to him, but the cases are clear that you can't shift the burden. The owner and contractor has to provide and place appropriate safety devices, and it can't be shifted to the worker just by saying, oh, the worker should have known to use that. They need to show evidence that the worker was instructed an immediate instruction and a direct instruction to do something, but they refused to do it for no good reason. That's the standard.
Your colleague mentioned there are two different theories of how the accident occurred. Is it your view that he would be entitled to recovery whichever it is?
Yes, Your Honor.
So could you explain under their
Yes,
account of how
yes,
the
thank
accident
you
occurred?
for the
Why?
opportunity. Yes, as they concede, if it was in the bucket and not secured, plaintiff recovers. The appeal is really about their theory that it was on the side, and that goes to trench collapse. And it's a 240 case because the bracing, they concede, Jason Beretta, quote, if trenching is performed in the vicinity of curb overlays, bracing should always be utilized. They're conceding that these safety devices should have been used. They're just trying to shift the blame to the defendant.
And is
or
it
to
your
the plaintiff,
position?
I'm sorry.
Is it your position that there shouldn't be a different standard essentially when it's a foreman? When the injured worker is a foreman, they're somewhat arguing that there's a different standard that applies because he could have fixed it. What is your view on that?
My view is that there is zero case law supporting that, and as Your Honor pointed out, plaintiff's supervisor was on site. So he would know if there was an instruction, and it was absent from his affidavit was any indication that any instruction had been given to plaintiff to shore it all. I would also just quickly, I also wanted to point to the Veluso case, because from their point two where they're arguing that trench collapses would not be a 240 case, that goes against Rivas from this case, but Veloso reaffirmed that the collapse of the side of a trench may evince the failure to provide adequate protection, where here they concede the braces should have been used. And so that was reaffirmed. The defendant was granted summary judgment in that case only because the shoring couldn't have been used in the direction that the work was going. It would have been contrary to the objectives of the work plan. But here it's the opposite. There's no argument that. Thank you.
So in reply, I would just like to highlight that this is plaintiff's motion for summary judgment, defendant opposing that motion for summary judgment. Defendant's entitled to all reasonable inferences that can be drawn from the facts in their favor. There was specifically a statement in the affidavit from Barada stating that that bracing is always supposed to be used by in the course of excavation of a trench whenever there's a concrete curb overlay. That regarding the Veloso case, that case, like this case, if the trench, the area of the trench where the concrete curb overlay fell was actively being excavated, which is reasonable to assume at this time, given the way that the accident happened and where plaintiff was standing, then the Veloso case would apply here.
Thank you. New York Concrete v. Contract Dispute.
May it please the court, Ian Sinclair with the New York City Law Department for appellants. Under the arbitrary and capricious standard, the Contract Dispute Resolution Board's interpretation easily passed muster, as did its alternative conclusion that petitioner identified at most an ambiguity that required clarification prior to bidding. First, the board's interpretation comported with the plain language and structure of the contract. Petitioners did not. Starting with the plain language, there is a complete absence of reference to individual soil samples in all the places where it needed to appear in the contract for petitioner's interpretation to make sense. Every item has to be bid in accordance with its measurement and payment provision, And that provision here says nothing about individual soil
To the
samples.
extent that there was any ambiguity with the contract, it was incumbent upon your adversary to bring questions forth with regards to that ambiguity.
Exactly. Section 9A of the Information for Bidders makes that very clear. That provision has been upheld by this court and the Court of Appeals in the L&L Painting Co. Case, which we cite in our brief. And both because of how their interpretation conflicts with the plain language and structure, and because of their own concession that they bid the item contrary to how they understood the work to be performed, the board correctly found that at most this was an ambiguity.
It appears that a city, I may get this wrong, but a city engineer or architect or something undervalued the process of sampling soil. How does that play into this?
Well, as we note in our brief, we don't think at the threshold level that that comes in at all because it's extrinsic evidence. And
Let's assume that it does.
Okay, so assuming that it does, the way that the board looked at it was correct. The board looked at the entire memorandum of bids, which included the $5,000 estimate, as well as the other 5 bidders, next highest bidders, which ranged from $40,000 to $750,000. And the board weighed that evidence in totality, and it concluded that on balance, it supported the notion that whatever, not knowing what went into the engineer's estimate, that on balance, that information just supported the view that this was a single all-inclusive price, as every bidder except petitioner understood. And for that reason, again, to the extent that there was any lack of clarity, it was incumbent on petitioner to raise that issue prior to bidding. If there are no other questions, I can reserve my time, rest of my time for. Thank you.
May it please the court. Previn Warren, the law offices of Gray & Gray LLC, on behalf of plaintiff respondent. Your Honors.
I just have a question, pulling on a thread that my colleague asked. In terms of your obligation to seek clarification if you were unclear, did that exist? And if it did, why does that not apply here?
Your Honor, no one is disputing the fact that if there were to have been an ambiguity in the contract documents prior to bidding the contract, it is incumbent upon the prospective prime contractor bidder to make due inquiry about that purported ambiguity. But here there was no ambiguity. This contract was perfectly clear, and both the dissenting administrative law judge of the CDRB as well as Justice Sweeting of the motion court agreed. What the city is attempting to perpetrate here is a post-execution, post-performance rewriting of the contract in such a way that would justify their non-payment for work that was bid and performed.
Sorry, I don't understand what you're claiming they're rewriting. If you're claiming it's clear, then I'm not sure why you bid essentially a very small amount for a piece of work that had to be done multiple times. But your bid for it didn't take account of how many times it needed to be done. So what is it? I don't understand your argument that the contract wasn't clear with regard to that.
No, my argument is that the contract was perfectly clear.
Right, I'm trying to understand what your claim is if you think the contract was clear.
What we're arguing, Your Honor, is that the fact that the bid schedule had a unit measurement designated as each for this item, and the specification associated with this item.
But it also has a unit of 1, right? So you were instructed to multiply it by 1.
The reason that the quantity was 1, Your Honors, is because at the time that the project was advertised for bid.
What does it say that in the contract?
Well, it says it in the contract, Your Honor. Well,
there's no asterisk on that 1, right? On that multiplier of 1.
No, but the quantity of 1, Your Honor, is used because the city didn't know at the time that it advertised the project for bid how many tests would be required because it was unknown to the city and all bidders alike.
So was it known? Okay, so was it known to you as to how many tests would be required?
No, Your Honor. And
you knew that it was more than 1.
No, Your Honor. The way that we bid the contract was exactly the way we were supposed to bid it. The way that you bid it is based on the estimated quantity provided by the city's engineer in the bid schedule.
The time that you entered the bid, you thought it would be 1 test?
We understood the contract as indicating that we would be paid and we were to perform this item based on an each unit measurement, which means that we'd be paid for each quantity performed throughout the lifetime of the project. And the reason this makes sense is because the number of tests that were required would vary in direct function of the total volume of soil that had to be excavated. At the outset of the project, and even before it was advertised for bid, and at the time of bid, the city had no idea what the total volume of excavated soil would be. So the reason that they astutely made this a quantity of 1 and designated it as each unit measurement is because they wanted the contractor to charge the city for each test as it was performed, and those quantities would increase as the total volume of excavation later revealed itself.
The city intended, they could have easily written that, right?
Well, the city didn't know. No, they couldn't have written it. They didn't know how many cubic yards of excavated soil would be required by the project.
They may not have known how many, but the fact that they didn't know how many leaves open the possibility that it's more than 1.
Yes, but we're not allowed to deviate from the way that the contract documents have been prepared in bidding the project. If the bid schedule says 14 quantities.
I'm just saying that you made an inference based on what's there.
No, Your Honor,
That's what it
respectfully.
appears to me.
No, respectfully, Your
Can
Honor.
we shift for a second to the standard of review?
Yes, Your Honor.
It seems like you're arguing that it's a de novo review rather than whether the interpretation of the board is rational.
No, Your Honor. We believe that the decision of Judge Sweeting finding that the board's determination was irrational or arbitrary and capricious should be affirmed. We're not asking for a de novo review. We're arguing that each designation, that this is in essence.
No, but that it was a de novo review. Hers was a de novo review, and our interpretation is we're looking at arbitrary and capricious.
Yes, Your Honor. No, we're not arguing that she did a de novo review at the Article 78
Judge
stage.
Sweden make her ruling on the interest of justice?
No, it's a funny thing that you mentioned that, Your Honor. It's actually unclear from the transcript of that second appearance before Judge Sweeting whether or not the decision is based on application of Hornbook contract law principles that would dictate that the contract should be enforced according to its plain meaning.
But her written order says nothing about the contract and talks about the interest of justice, the law of equity, and unconscionability. There's nothing at all about the contract.
There's a substantial portion of those transcripts in which she talks
No, I'm
about.
talking about in the written decision, there's nothing that refers to the contract.
She refers to the absence of any ambiguity in the contract and therefore the absence of any burden shifting obligation that would make it incumbent upon the
In
contract.
the written agreement, she doesn't talk about any of that.
Your Honor,
I'm sorry, in the written order, she doesn't refer to anything about the ambiguity or the contract at all.
Your Honor, you can get to the ultimate decision rendered by Judge Sweeting through the application of equitable principles, certainly, but I would submit that.
But we don't usually, that's not how we decide contract cases.
Certainly not. I think that the plain language of the contract and basic contract law propositions would support the finding of Judge Sweeting as well, because the contract plainly directed the contractor to bid a unit price for each quantity of the soil sampling item that they were to perform. The city's engineer indicated 1 as the estimated quantity because at that time, they didn't know how many quantities of that item would need to be performed in order to complete that item. They didn't know that because they didn't know how many cubic yards of soil.
How do you know that they did not know this?
Because subsequent to the awarding of the contract and after we submitted our initial proposed sampling plan, the city indicated that the quantity of soil to be excavated would be 3,500 cubic yards of soil, which requires 7 tests. Later, as performance continued and soil continued to be excavated and samples were continuing to be taken, it was learned that the volume of soil that would ultimately be required to be excavated was exponentially greater, at which point the city granted and executed a change order for the expanded quantity of soil to be excavated, but then stuck to its guns with respect to the fact that only that the soil testing item was a lump sum item, which it was not. The spec itself says that the contractor is required to conduct 1 sampling test per 500 cubic yards of soil.
The spec also says that this should include all costs for labors and materials related to the development.
I'm glad you brought that up because this is something that there shouldn't be any ambiguity about. The fact that the specification says that all costs are included in this item just means that all costs associated with the performance of this item are baked into the unit price bid by the contractor for that particular item, for each quantity of the item that they perform.
That's the thing that you're writing in, the each quantity.
Well, Your Honor, the all costs the fact that the specification refers to all costs being included with the item doesn't take and transform an item that has been designated for measurement purposes for payment, performance, and bidding as each and turn that into a lump sum item. Elsewhere in the bid schedule, there's plenty of items that are listed as lump sum items. They have a quantity of 1. The each item is meant to mean exactly that, each. The fact that there's other aspects of the work that have to be performed in addition to the actual testing itself, such as the preparation of the plan and the
But if we read it that way in terms of a future calculation, then the calculation that's already been prepared and is in the contract would be meaningless.
I'm sorry, could you repeat the question?
So you're stating basically that each per unit bid is something that would be multiplied in the future, right?
What I'm saying is that each means that the contractor shall be paid for each quantity it performs as the project proceeds.
So we would not know what that calculation would be until sometime in the future. Is that correct?
Until the contractor begins excavating and identifying through testing the levels and concentration of contaminated soil.
There's a repayment schedule in the contract. So wouldn't it therefore render that repayment calculation meaningless?
The repayment,
Isn't there there's a payment calculation within the contract, isn't there?
there's a payment calculation, Your Honor, that says that in order to bid the item, you multiply the estimated quantities by the unit price bid in order to arrive at the extended cost.
Exactly.
Yes, and so we are required to bid.
So your interpretation, wouldn't it be, is that not inconsistent with that payment calculation?
Not at all, Your Honor. The fact that it's written that way is indicating that we're providing the price that we're seeking to charge the city for each quantity, one quantity, as indicated in the bid schedule. The resident engineer's own estimate, who prepared the bid schedule and was responsible for the pre-planning, pre-construction process, they identified a figure of 5,000 for this same item.
Which is underestimate.
Which is not an underestimate. The third-party cost associated with each soil test that is taken is at least $1,500. So to suggest that the city thought that $5,000 for this item would cover 56,000 cubic yards of excavated soil and 113 tests is preposterous. They knew that it was.
That can go both ways, right? Because the fact that you would bid such an amount, why wouldn't the city take you at the word that you understood what was the calculation and that's what your outcome was?
Well, the reason that they accepted the bid figure of 2,500 for that particular item was because it was consistent with the resident engineer's estimate. In fact, on the first page of every bid schedule appearing in every prime contract for every public project undertaken by this city, it says that a contractor in bidding the project, if their unit price were to dramatically exceed the estimated unit price of the resident engineer, the bid will be rejected as non-conforming. So if anything, the fact that the resident engineer's estimated value of 5,000 was consistent with our own value shows that they understood and interpreted the item and the spec in the same way that we did.
Thank you.
4 points to focus on, Your Honors. The first is that petitioner is repeating again that the city didn't know or didn't state the amount of soil excavated. But as we note in our brief, the bid schedule clearly sets forth an estimate of 119,000 cubic yards.
The city could not have known, because if the city did know, then it wouldn't have stated, then the contract would not have stated what it states, right?
Right. I mean, there was there were contract drawings that outlined the limits of excavation. There was an estimate for the likely cubic yardage that would take. So to the extent that petitioners, most of their argument relies on this premise that this was an unknown quantity, that simply wasn't true. And at the very least—
Not only unknown quantity, but it could not have been known at the time.
That's what their argument is. But there was a known estimate because the project had a scope, and the scope has limits of excavation to the extent that this is about digging trenches.
There was a known estimate, but it was possible that that estimate would be incorrect, and therefore it would have to be recalculated, right?
Of course, and that's totally possible. But the estimate that was listed in the bid schedule is more than double what was ultimately excavated. So to the extent that they're saying that the city pulled the rug out from under them, that simply wasn't the case.
And you had mentioned before that other bidders did not interpret it this way.
Exactly, and that's exactly. And for good reason. The petitioners keep, as Your Honor noted, they're reading the phrase per unit of soil sampling into the measurement and payment provision. It's not in there. It says—
Although the word each.
The word each is there, but each, as we explained in our reply brief, has no intrinsic content. It's defined by the words around it. And the measurement and payment provision and the bid schedule both refer to the entire scope of work. In the bid schedule, it has a 1.0 unit, which reasonably implies 1 unit for everything, which is consistent with a dozen or more other uses of each.
Well, but on the same page, they list under canopy trees 300 each, and their calculation is a certain number for 100 for a single item, and the overall item is 300 times that.
Exactly.
So why isn't it reasonable that when it was a unit of 1, they would say the same number for the unit item and the overall number?
It should be. The only time that the unit price and the total price match is where there's more than 1 unit that's anticipated. But what petitioners are asserting is that this was the lone item in the bid where there was an unknown total amount and therefore an unknown total cost. But that's simply not how any of the contract items work. The extended amount, column 5, always sets forth the likely total amount for that bid item. It can certainly change, and the contract allows for modifications that where there is true extra work. But where there's only a single unit contemplated, it sets forth a quantity of 1, which is exactly what was the case here.
Thank you both. 71st Street v. Frankel. Let me see.
Good afternoon, Your Honors. May it please the court. My name is Maurice Heller of the firm of Foster Garvey PC, and I'm here for the defendant appellant, Eric Frankel. So this appeal asks the court whether a cooperative can terminate a proprietary lease, seize an apartment, sell the shares based on an alleged failure to maintain insurance when the notices of default and to cure were defective, when the notice of termination was defective, and the lease does not authorize specifically termination of the lease in the event of a failure to maintain insurance, and in addition, that certain material facts remain disputed since the decision of the IAS court was rendered.
That's a lot. That's a really long question. As to whether.
It is a lot,
Maybe
Your
we
Honor.
could maybe you could break it. We could break it up into specific issues. And I want to address one specific thing in terms of the failure to procure insurance. Is that really disputed when your client admitted to not having insurance on the co-op from 2019?
No, there is no dispute that there was a lapse in insurance coverage. The issue is whether or not there was a proper notice given under the terms of the proprietary lease and under New York law as to whether or not there was a default and what needs to be done in order to cure. Our position is, and we can talk about the specific issues relating, and there are many issues relating to this particular notice to cure. I mean, one thing you can do is go through sort of a thought analysis. If you look at the notice to cure and you substitute in there for failure to maintain insurance, failure to pay rent. And then it goes on to say you didn't pay rent in August, and therefore you didn't pay rent for 3 months, and therefore you're out. Doesn't say how much. It doesn't say what you need to pay in order to alleviate the default. It doesn't say whether or not there were late fees or convenience fees or administrative fees. It doesn't say anything. All it says is that you didn't pay rent in August, therefore you didn't pay rent for 3 months and you're out. That is, I'm sorry.
Are we talking about the October 4th, 2021 notice of default?
Yes, Your Honor.
So
that mentions the failure to maintain insurance. There's certain sections, right?
Does.
In B and C.
So I'm not understanding.
What about the cure? What about, other than saying it was virtually impossible to get insurance, what is in the record as to the efforts that your client made to cure this default by getting insurance?
Sure. So there was, the problem was that the insurance companies, given the level of damage in that apartment, by the way, that apartment was not occupied. There was water coming in from another apartment above. which the co-op was responsible for. So given the level of damage, the insurance companies refused to issue new insurance unless the damage was remediated. So part of what the tenant was trying to do was to get access to the apartment, which he does not live in, to cure the purported damages to the apartment. And the co-op obstructed that at each and every level.
Did he
So
try
you
different
can't-
insurance companies?
Sorry?
Did he try different insurance companies?
Yes, the consensus was amongst the insurers who would provide, by the way, this is not homeowners insurance
So,
because,
counsel, is there anything in the record? Did he submit any evidence to support his contention that he was unable to obtain the insurance?
yes, there is a statement and an affidavit that the defendant put in, and in addition, there is an
It said it
email
would be
that he
close to-
received.
That's
So that
it's
you're ta-
close to impossible, right?
Right, you're referring to the November 5, 2021 email from the insurance broker
That's correct.
stating that it's extremely difficult, if not impossible. Anything else?
That's the defendant has to rely on his insurance broker. He doesn't go out into the market to obtain insurance. He's got to rely on the insurance broker to do that.
Is this individual the only insurance broker in New York?
No, he's not. And
So I'm not understanding. The question was, what efforts did he make in order to obtain insurance? And you're stating that this insurance broker stated that it's extremely difficult, if not impossible. Any other evidence in the record to support that he was unable to get the insurance?
aside from his own statements in the affidavit, the answer is no. That's the evidence. So just to wrap up,
On rebuttal, thank you.
thank you.
Good afternoon, Your Honor. Matthew Ullman for Respondent.
Counsel, I just want to start there with the impossibility, right? If he needs access to the apartment to have someone inspect so he can get insurance, but he's not getting access because the co-op will not allow him into the apartment, so he can't get insurance to cure the defect, why isn't that an impossibility?
So I want to point, Your Honor, and thank you for the question, to record page, I'm sorry, I lost my place in the line. Record page 67, paragraph 16. He was provided access on numerous occasions, both before and after he was denied the insurance by Hartford. He was denied insurance by Hartford in June 2019. He was provided access on the following dates: February 13th, 2018, May 6th, 2019, May 30th, 2019, August 17th, 2020, September 3rd, 2020, March 17th, 2021, and August 4th, 2021. He did not.
August 20, I'm sorry.
I'm sorry, August 4th, 2021.
And then we have the email November 5, 2021 stating that it's going to be virtually impossible.
Correct, Your Honor, because that was by his own doing. I want to point out that this is an issue that has been going on for 15 years. And by his own admission, he did a number of things that were highly questionable regarding this matter. In fact, by his own affidavit on record 334, he admits that the stipulations that he relied upon for his civil contempt did not include a timetable for the sale or renovation of the apartment, and I would never have agreed to one. He then says the co-op allowed me access on several occasions, but did so grudgingly. He was provided access. He simply let his own insurance lapse, and then when the insurance lapsed in 2019, he refused to tell the co-op until the co-op demanded it. And then he admitted that he did not have the insurance for the last 2 years, and then begged for forgiveness by demanding access, of which the co-op had given him on a number of occasions. And on each one of those occasions, he did not renew his insurance, and he did not make the supposed repairs. But the repairs have nothing to do with the retroactive nature of the insurance default. He cannot get retroactive insurance. That's part of the default.
So you're saying regardless of whether he actually obtained insurance in 2021, because there was no insurance in 2019 through 2021, he was still in default, and therefore there was no way to cure.
And that's a material breach under the terms of the lease.
When
And
did when did the co-op become aware that he didn't have the insurance?
August 2021.
And then the notice of default was sent in October of 2021.
Yes, because that's in time when we became aware that in fact this apartment was uninsured. Because again, and if you look on record page
And
190.
did the proprietary lease have, give the shareholder an obligation to notify when there's a lapse in insurance, or if, whether or not they have insurance? How's that reporting go?
There's no obligation, but the co-op certainly asked, and the shareholder is required to have insurance, and so the failure to have insurance is a breach under the lease.
But it doesn't state, I'm looking at that portion of the proprietary lease, it doesn't state that they have to notify the board of directors or the co-op if they lose insurance.
Correct, but once in fact the default was made known to the co-op, then of course the co-op can issue a default based on the failure to have the insurance. It's still a default under the lease if we found out about it and in fact he did not have the insurance. And he just made an admission that he did not.
And he never, I mean, that was in 2019 when it lapsed, and then 2021, the discovery, and in between that time, there was no attempt, was there, to get insurance? Or not attempt, but there was no securing of assurance.
Correct, and worse yet, Your Honor, when they found out that we had attempted to sell, I want to read, if I may, I know I'm out of time, but this is significant going to what's happening here. His affirmation states that he knowingly filed a false UCC1 to prevent the sale of the apartment. Record 342, paragraph 36. In order to stop this flagrantly illegal conduct and to make it known to any prospective buyer that the ownership of the apartment is disputed, I authorize the filing of a UCC1 with the New York County Clerk, setting forth the estate's rights in the apartment, which was filed on or about February 28, 2023.
Right, but then it was filed in, I thought it was in January, but regardless, he did cancel the filing.
But that was the issue, Your Honor, because that put every single purchaser, as Your Honor knows, on notice that there is a dispute. And he did it knowingly, he did it purposely, and he did it knowing that it was...
Well, he filed it apparently on January 24, 2023, and he canceled it sometime thereafter.
Yes, but
immediate thereafter.
But his own response to that, and I want to use his words, Justice Weber, is, I was advised that there was no further need for the UCC1 since it had already provided notice to the world of the estate's claim to the apartment and effectively hindered the co-op's illegal activity. In other words, he did it, and then he revoked it only and receiving a letter from our firm, and then said, well, the damage has already been done, and I did that knowingly.
Thank you.
Thank you, Your Honor.
Couple of things, Your Honors. It's not true that the co-op first received notice, even by its own reckoning, in August 2021 of the lapse in insurance. That happened in March, and that's documented in the record. There were communications between myself and the co-op's counsel where we asked on the defendant's behalf to enter the apartment to make certain renovations and repairs for the purpose of obtaining insurance. And that reason was denied specifically by counsel to the co-op. You cannot go in to make any repairs if the purpose is to obtain insurance. That's documented. It's all over the record. It's very clear.
But do you not agree that the insurance lapsed in 2019?
The insurance lapsed in 2019.
And did he not have an obligation under the proprietary lease to maintain that insurance?
Your Honor, he had an obligation, and let me just point out, under the House rules, he also had an obligation if he were an occupant of the apartment, and he was not. You look
Yeah,
at this,
he had been ejected from the apartment in 2014.
he voluntarily left the apartment. It was part of a settlement with the co-op.
Okay,
There's no
fine.
order
So
of
he left in
ejectment.
2014. The insurance lapsed in 2019, but he still had permission to enter could have obtained permission to enter the apartment between 2014 and 2019, but also he could have still maintained the insurance.
He could have maintained the insurance, and I think the materiality issue comes into play. But I think what the court needs to pay mind of is that there is not a single case that we have found where a notice to cure leading to an eviction was based on a lack of insurance in a residential situation. That is almost unheard of. It doesn't happen in this state. So that's what they're trying to do, and they use.
But the lease here allows for that. It's not as if they're just making it up. The lease says that if you breach a covenant of this particular lease, it can be terminated.
It does say that.
One of the covenants of the lease is the insurance.
Yes, and the specific provision dealing with insurance has an exculpation provision at the very end of it. So basically, they're attaching a remedy to that specific clause in the lease where it says that the co-op cannot be held responsible for damage. That damage if there's no insurance, is the responsibility of the tenant. That is unique to any other provision in the lease. There is a very specific clause.
That doesn't.
Yeah, go ahead.
That doesn't relieve him of the obligation to get insurance.
No, it does not. But again, in order for it to become a default, the default has to be material. You can't just simply, for example, there is a provision in the House rules that says.
Examples. Thank you very much. Thank you both.
Okay, thank you, Your Honor.
LeBron v. Bronx Heights, Beulah. Yes, whenever you're ready.
Good afternoon, Your Honors. May it please the court, Abid Bouyan, Wade Clark Mulcahy for defendant appellant Prestige Management. The court below issued 2 orders on the same day that cannot be reconciled. On the one hand, the court found against my client on my client's counterclaim for breach of contract, this is page 14 of the record, that Bronx Heights, my friend on the other side, did purchase a policy of insurance for my client Prestige, and quoted the policy covers any person or organization while acting as your
So
real
you
estate.
moved to amend the pleadings, yes?
Yes, Your Honor.
And the court denied your application, is that correct?
That's correct, Your Honor.
Based on lateness?
Well,
Is that what the decision was? It was basically because it was too late?
that's part of the decision, Your Honor, and part of it was also the court found, even though Bronx Heights never argued it, that there was the amendment would be prejudicial.
Right.
But the court can't make that.
Was there any showing by Bronx Heights that it was prejudicial?
No, Your Honor. The only showing, if there was, to the extent there was any showing, it would have been prejudicial to the insurance company, Star, which is not a party either here on appeal or below.
And so the court stated lateness equals prejudice, and that was it.
That's effectively the jump that the court below made, Your Honor, yes. And here, the court can't do.
Thank you.
If there are no further questions, I'll reserve for rebuttal. Thank you.
Good afternoon, may it please the court. Joel Simon for the respondent from Smith Major. The lower court denied the amendment based upon several grounds.
I saw only lateness.
Actually, Your Honor, they also said it lacked merit.
Okay, what is the prejudice to Bronx Heights for the
Well, Your Honor, aside from the fact of whether they even need an amendment and whether they need an affirmative defense or not.
Well, that's up to them, right?
That's another issue. They are claiming that they're an insured under the policy as a real estate manager. However, they've never tendered, they've never brought a DJ against the insurer, and for them to be claiming now that they are a real estate manager and they were acting in their capacity as a real estate manager causing this incident, after discovery has been completed, what, 2 years ago, 2 years prior.
That's what I'm asking. So what's the prejudice to you?
The prejudice, Your Honor, is that if this had been requested at an earlier point in time, putting aside the merits for a moment, discovery, the motions would have been conducted to demonstrate that the actions they were taking relating to the underlying occurrence were not as part of their function as a real estate manager. Therefore, they would not be entitled to the relief they're requesting. However, at this point, discovery is closed. We can't pursue that, we can't develop that, and it affects our contractual indemnity claim that we have, it affects who pays that claim, and at this point, as the lower court noted, given the lateness, given the prejudice of how it affects our claims, and given the fact that there is no factual predicate for the amendment, as there's been no determination of coverage, this is not an issue which will be determined in this matter. It's a separate issue.
So the amendment would be to add Prestige as an additional insured?
No, Your Honor. The amendment would be to assert an affirmative defense for stating anti-subrogation. However, there's no basis, there's no determination.
As relates to Prestige, right?
As it relates to Prestige.
Okay, wasn't that already, wasn't there a motion for summary judgment that included that issue?
Yes, Your Honor. The lower court did not grant Prestige's application. The lower court noted that we did not appear to have breached, as there was language in the policy, but they've never even written to Star requesting the coverage. They keep emailing me saying we want the coverage. I'm not Star's attorney. I'm not Star's counsel. I cannot bind Star. I cannot represent Star in this matter. I am not their attorney. So
is there any dispute that Prestige was an additional insured?
Yes, Your Honor. First off, as I mentioned, they've never tendered the Star. There's never been that determination. If they were not acting as a real estate manager in the occurrence of this incident, they're not going to be entitled to additional insurance. But that's not my problem, my concern, my issue. The fact is that it's like trying to bring amendment to bring a breach of contract affirmative defense when there's absolutely no proof that there is a contract. There's no DJ pending. There's not even a tender to Star. And there's no, as I mentioned, there's no factual predicate to this.
Thank you.
Thank you.
To clarify, there is a pending declaratory judgment action. Neither Mr. Simon nor I are counsel on that DJ action, but we refer to that in our brief. It is pending. It was so this is on page 13 of our moving brief.
And was there an agreement called a property management agreement that was signed?
Yes, Your Honor, there was. And whether my client Prestige was functioning as a real estate manager or a property manager, I think the law is clear on that, but it doesn't matter what I think. That is for the DJ action. That's for the coverage action. It's not Mr. Simon's problem. It's not mine either on this day. But I think to correct my friend on the other side, there was a tender. The earliest tender, and this is in our fact section, November of 2020, and this is on page 4 of our fact section. Tender was initially made on November 11th, 2022. There are email correspondence. I mean, I guess I'm sorry to the extent we included Mr. Simon on those correspondences, but generally speaking, defense counsel are sometimes involved in tender discussions. There was a tender made. That tender had been denied effectively because they never accepted acknowledgement of the policy and of the coverage until my friend on the other side admitted that his client purchased insurance for my client. That is what implicated the anti-subrogation agreement. Thank you, Your Honors.
People v. Jamal Ingram.
Good afternoon, and may it please the court, Jacqueline Shelton here for Jamel Ingram. Because the court below denied Mr. Ingram's motion squarely on the merits, the issue on his appeal today is also on the merits. And his
So,
jury
counsel,
trial.
is this part of your LaFontaine argument?
Yes.
Could you explain that to me, please?
Yes. So the court below simply held in its holding that Erlinger does not apply to the factual question of tolling, so thus deciding it on the merits. Although there was in the alternative, it is not retroactive. That ruling was clearly in error, and the prosecution does not defend that ruling because his conviction was not final under Griffith versus
So his
Kentucky.
conviction was in 2022 and Erlinger was 2024. Is that correct? Something like that? Did I get that wrong?
Yes, that's correct.
Okay. And so you're stating that, again, under LaFontaine, the court considered this solely on the merits, stating that Erlinger does not apply. So therefore,
Yes. So the question here is whether that ruling was correct.
whether Erlinger applies
Whether
or does not
Erlinger
apply.
Applies, exactly.
Okay.
And every time this question has gone before the Supreme Court since the Almendarez-Torres exception, there has been a distancing from that narrow exception. And Erlinger goes to great pains talking about the historical underpinnings of the Sixth Amendment, and very interesting, but a lot of ink spent on talking about why this right is so fundamental to our legal system. It describes Almendarez-Torres as an outlier and at best an exceptional departure from historic practice that persists as a narrow exception. Even in dicta, going so far as to say Almendarez-Torres may be, if it's presented again, maybe on thin ice. And so we really have to take the Supreme Court at its word that any fact that is used.
Oh, you mean the U.S. Supreme Court?
Yes, the U.S. Supreme
Okay.
Court at its word that any fact that is used to enhance a sentence must be determined by a jury.
Counsel, what I don't understand is that in the allocution about whether he was a violent predicate felon, your client did not dispute any charges made in that statement. So even if Erlinger did apply retroactively and to him, I don't see that there are any questions of fact left given that. So I don't understand what you would get from it.
So there's a couple of issues sort of baked into that question. I'll try to answer. So he filed the 440-20 arguing that his jury right had been violated, and that's the exact argument that we're making today. That allows the trial court to have the opportunity to fix any issues below, even if he did not raise them or is raising
But
the
if he
sentencing
said he had
predicate
no
for the
dispute
first
with
time.
any of the facts, I don't know what you'd have a jury trial about.
Well,
He raised the tolling when he made that motion?
Yes, making the exact argument that the court addressed, he makes the motion saying that his jury trial right was violated.
Is the fact that he's not disputing the charges itself different than the tolling calculation that is used to determine whether or not he's a predicate? Because when you're determining that particular part of sentencing, you're really looking at, was this person incarcerated, period, right? It's math. That's what you're doing. You're doing the calculation. If he's not disputing the charges, which he could have done, but he didn't, but if he's not disputing the charges, what is the factual determination that needs to be made?
So the question is where he was at a particular time during that 10-year widening statute that allows the enhancement to be applied to more people than just those that have a conviction within the last 10 years. So
I'm sorry, repeat that?
So during those 10 years to enhance his sentence, the factual question is, where was he, essentially? And so
Well, you said something about other people. That's what I did not understand.
I probably phrased it poorly, but essentially the tolling applies.
Right, we know what the tolling. We know what the tolling is. Okay, whether he was incarcerated or not incarcerated, and what period of time that he was incarcerated.
Yes.
But I don't know that that responds to my colleague's question.
I'll try again. So, so the court below did not find waiver by admission, but to Your Honor's question, he was never specifically asked about tolling. And I think given the expansiveness of how the Supreme
Whether
Court...
he challenges any charges
Right.
in the predicate felony statement, right?
When you
But
are
charges include the tolling, right?
Right.
And in fact, what you're looking at in the predicate felony statement is not charges, it's conviction, right? It's the fact of conviction and then the tolling.
Yes, but...
So when you are arraigned on the predicate felony statement, the question is whether, is that you, and were you convicted of X, Y, and Z? Those are the questions, and do you dispute those convictions? You're never asked about tolling.
Well, I think given the brevity of the constitutional right at play, that you should be, because there's a statute that prevents him from...
It may well be that what you think it should be. But the point is that's not what it is, and that is not what is stated when an individual is arraigned on the predicate felony statement.
I think when I considered this question myself, if someone was deprived a jury trial at guilt or innocence, but was never told that they had that right, that's the same depth of issue that is presented here. There's actually a provision of the CPL that prevents him from exercising his right to a jury trial. So it shouldn't be a situation where it's sort of snuck in.
That's assuming, are we not assuming that Erlanger applies?
Yes.
Yeah.
Yes.
So you're making that assumption.
Yes.
Right. But we may not be on the same page with you in terms of that assumption.
Yes, that is true.
You have time on rebuttal.
Thank you.
Good afternoon, Your Honors, and may it please the court, Andrew Chung for the people.
Well, I just want to expand on the question that I asked your adversary. In determining whether someone was incarcerated for a specific period of time, do determinations also have to be made, for example, if it was in New York State, which is very obvious, which is easy, we know it's a felony, it's what, and the time frame applies, but if it was out of state, someplace else where maybe they calculate it differently, are we making that distinction when we're dealing with predicate statements?
Right, so I believe in the text of the penal law itself, it doesn't specify necessarily in-state New York incarceration is the only thing that's considered. I think it expands it to any incarceration between the time of commission, between the two relevant crimes. And so actually, I would like to just begin by first addressing...
and just to add on that, I'm sorry.
No problem.
That would then just still be a mathematical calculation.
Right.
Not factual.
Right. I think in that instance, a lot of the documents that are typically used to determine a defendant's past incarceration will often include out-of-state felony convictions and things of that nature. And so
this particular one states you were incarcerated at downstate from June 20th, 1997 to December 13, 2002, Ulster from March 30, 2004 to January, Ulster from May, et cetera, et cetera.
Right.
So there were the charges as well as the periods of incarceration.
Right. And so I think in the NICID report that's in the court record on appeal, it includes both the location of the dates of the places of incarceration as well as the relevant time periods, i.e. when the defendant went in and when the defendant went out.
But he was specifically arraigned on that. That was specifically stated to him during.
Oh, yes. Sorry, Your Honor.
Then it states, if you wish to dispute any charge in that statement, you may specify what particular charge. So again, it talks about charge. It does not talk about period. It talks about charge.
Right. I think in this instance, immediately after listing all the dates of incarceration allowed, right immediately after saying that, the clerk stated that if you do not dispute any charge in that statement, presumably this would also include the dates of incarceration because those are relevant to the determination of whether he is in fact a second violent felony offender, which is what they were there to adjudicate. But I'd also just like to briefly touch on a point that Your Honors mentioned earlier. There are separate preservation issues in this case. The first initial thing to consider is whether or not the defendant has in fact preserved a factual question such that we can even get to the second and independent preservation ground of the constitutional argument. Here, because the defendant did not preserve a factual dispute to the allegations in questions, it's arguable whether or not the Erlanger issue here is even adequately presented before this court. And the Court of Appeals recently in People versus Hernandez made that same determination. And this court as well in People versus Gomez, I believe that case also contained a 440-20. This court also noted a distinction between waiver and preservation. In our case, both waiver and preservation are separate but independently sufficient grounds to procedurally bar this case.
Well, see, that goes to your, I'm sorry, go ahead.
What about your colleague's argument that LaFontaine prevents that because the court ruled on the merits, not on waiver?
Right, Your Honor. Well, under LaFontaine, the appellate court may not consider arguments that the lower court either expressly rejected or did not rule on. Here, neither is the case. In the actual opinion of the decision itself, the judge mentioned the fact that all parties agreed that the defendant in fact qualified as a second violent felony offender, which he could not have done if the tolling period did not include the 1996 conviction. And so we would argue that in this instance, LaFontaine does not preserve a bar. But even if it does, the factual preservation issue prevents this case from even getting to a consideration of the constitutional preservation as a threshold matter. Now, I'd like to just briefly end by touching on the merits. Here, insofar as Erlanger was nothing more than kind of a textbook application of Apprendi to a new set of factual circumstances, this court should follow its existing New York Apprendi line of case law and find that the Erlanger issue just simply doesn't apply here. I would also just like to, if I could just quickly conclude, if Your Honors wouldn't mind.
Quickly.
Right. So on the merits points, I would simply point out the fact that the fact finding here is just simply not the same thing as the fact finding at issue in Erlanger and the Apprendi line of cases. And here, even if the defendant clears all those hurdles, the factual preservation hurdle, the constitutional waiver hurdle, the merits issue, there's still the harmless error issue here. And because the defendant admitted to the dates of incarceration, and because in the record all those facts are clearly adduced, any error here would clearly be harmless. If Your Honors have no further questions, I would rest on my brief and ask that you affirm.
Thank you.
So just very briefly, the waiver by admission argument clearly does have a LaFontaine problem because the court did not determine it on those grounds. The preservation issue.
By ruling that Erlanger did not apply and therefore defendant was a predicate, then obviously the court is taking into consideration the waiver or the tolling periods.
The court did not rule that, though.
But the fact that the defendant did not object to the tolling, there's nothing for the court to rule on.
Well, there's the question of did he freely admit, because the
Is there any evidence that he did not freely admit?
Yes, because he was not advised of his, he wasn't asked about it, and I think that's an important
He wasn't asked about what?
About whether he is, in comparison to pleading guilty, the colloquy should be, you have a right to have a jury trial on this. Do you?
But you don't.
Freely admit. Well, if Your Honor,
that's your assumption again, but you don't. And as you know, under the judiciary law, you cannot impanel a jury to make that determination.
Right. So that's the question.
So what happens here to the New York sentencing scheme? That there would just be no predicate statement, no predicate sentences. Is that where Erlanger wants us to go?
No. I think that's why it's so incredibly important to address this question on the merits so that there is an answer solidly and affirmatively, and then the legislature can act as it does.
Again, you're assuming that that the ruling would be that Erlanger does not apply.
Well, eventually this will be decided. But just very briefly as to preservation.
But you didn't answer my colleague's question as to how he did not freely admit, where he was told, or it was stated by the clerk, the periods of incarceration, Ulster County, et cetera. He did not object to any of that. He didn't say, no, I wasn't in Ulster County Correctional Facility from March to whatever date.
Yes. But the 44020 acts as that proper vehicle. Under People v. Juergens, that preserves the issue. The Hernandez case that my opponent cites, that was raised for the first time on direct appeal. So there's a hugely different record there. You know, if you don't file a 44020, and then in the Gomez case where there was a 44020.
So in his 44020, does he state that those periods of, I was not incarcerated during those periods?
He does raise factual challenges, but doesn't, you know, at the...
Does he say that that is correct? I was not incarcerated during that period of time, or that the calculation is not a 10-year period?
We raised an overall objection to the accuracy of these types of records, which the court
No. Was there did he state, I was not in Ulster County Correctional Facility from March 2002 to February 2003?
No.
Thank you. Thank you both.
Thank you.
Still Point Meadows, PH 62.
May it please the court. Good afternoon, Your Honors. My name's Alan Carl, and I represent the plaintiff appellant, Still Point Meadows. This appeal presents a fairly straightforward question, whether a court may dismiss a complaint for breach of fiduciary duty at the pleading stage, where the governing condominium documents are ambiguous and the complaint plausibly alleges bad faith and retaliation. The complaint alleges that the removal and reinstallation of the pavers at issue was required by the board in order to replace the building's membrane roof.
So the first cause of action, first cause of action on the amended complaint was the breach of fiduciary duty.
Yes, sir.
Is that correct? So what was the breach of fiduciary duty?
The breach was the fact that the board, after having entered into a contract for the removal and reinstallation of the pavers, and having presented in audited financials, having paid for that work, and having presented in audited financial statements that these costs were the responsibility of the condominium, the board reversed its position after the plaintiff terminated discussions with the defendant 2 years after this whole thing started, with respect to the defendant's desire to acquire a portion of the plaintiff's premises for an elevator. Within a month of the plaintiff's termination of those discussions, the defendants reversed course and suddenly back-billed my client for the cost of removing and replacing the pavers, then imposed escalating and ultimately confiscatory late fees over and above that in retribution as a vendetta.
Did the bylaws provide that the plaintiff was responsible for the paving, the paver?
I'm sorry, Your Honor?
Did the bylaws state that?
The bylaws do not, they're silent in that regard. The bylaws do not
maintain, the bylaws do not provide that the plaintiff has to maintain the flooring on the terraces?
They have to maintain the terraces.
The flooring on the terraces.
Yes. It does provide that they have to maintain the terraces for normal maintenance. It also provides that where there's extraordinary or structural repairs that are required, those costs are to be incurred by the corporation, by the condominium. Now, what happened here is very simple from a chronological standpoint. Before the work was undertaken, the board initially took a position that the cost of removing and reinstalling the pavers was my client's responsibility. I then sent a letter to the condominium's council citing the specific provision of the bylaws that says where there's extraordinary or structural repairs that are being made to the terrace.
So that was my question. So you're stating that the bylaws do not require that that the bylaws do not hold the plaintiff responsible for the paver?
Yes.
And where in the bylaws are you reading that it's not the plaintiff's responsibility?
Well, section 6.9.2.2 of the bylaws contains provisions that say that the plaintiff is obligated to handle the normal maintenance and operation of the terrace, but with respect to structural or extraordinary replacements or repairs, it's the obligation of the condominium. Here we have a situation where the pavers needed to be removed and replaced only because the membrane roof was going to be replaced, and that was a structural repair that benefited the entire condominium. It wasn't that the plaintiff wanted to replace and remove the pavers. This was a work that was done in conjunction with the repair and with the replacement of the building-wide roof. It was a structural undertaking.
And didn't they not agree with your interpretation after you sent that letter?
No, they did not. Actually, they accepted that interpretation, and they entered into a contract with the contractor to pay for the entire roof restoration, including the removal and reinstallation of my client's pavers. They then paid for that work. They then accounted for that as a condominium expense in their audited financial statements, which management prepared.
Also, the fact that they paid for it doesn't mean that they weren't intending on seeking reimbursement, right?
I'm sorry, what was it?
The fact that they paid for the pavers doesn't mean that they were not intending to seek reimbursement.
Well, Your Honor, it's possible that 2 years after the fact, they could have sought reimbursement, but the situation here was not as simple as that. You had negotiations that the Board of Managers had been undertaking with my client to acquire a portion of my client's condominium to install an elevator. My client terminated those discussions in January of 2019. A month later, the Board of Managers reversed its prior course of conduct and said, we're going to stick the cost of the pavers back onto my client, even though they had contracted for it in the name of the condominium as opposed to in the name of my client as they had a right to do.
And
as
so
attorney-in-fact.
you're correlating this with some type of a breach of fiduciary duty and some type of antagonism between the board and your client?
Yes, ultimately, yes. That's exactly it, Your Honor. That there's bad faith, retaliation, and vendetta.
No, I was referring to the March 24th response to 2017 letter that they sent in response to your letter. What did that letter say?
There was no response to my letter, Your Honor. There was a March 17th letter from the condominium.
So I thought the record said March 20th you read a letter saying we're not responsible. And I thought the condo's counsel wrote back on March 24th saying the unit owner is responsible. No, that didn't happen?
It's quite the
No?
reverse, Your
Okay.
Honor. There was a letter from the condominium's counsel. I wrote to the condominium's counsel citing the specific provision of the bylaws governing.
This is the March 29, 2017?
Yes.
Right.
Yes,
The
and I did-
condo's counsel never responded to the letter.
Never respond to that letter, but I did.
You have time on rebuttal. Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the court, Alexander Davis on behalf of the respondents. I want to start off by addressing a few points.
So could you address that? So it's clear, March 29, 2017, plaintiff's counsel requested that the condo reconsider its opinion that the pavers were the responsibility of the plaintiff, and the condo never responded to this letter. Is that correct?
That's correct, Your Honor, but the condo never reversed its position. It stated that under the bylaws, specifically 6.12, 6.922, that the unit owner is responsible for normal maintenance of the paver stones. That's further documented in the April 2017 minutes, where they had a meeting and the board maintained that position and specifically requested that general counsel coordinate with plaintiff's counsel as to the paver work. At no point did this board ever reverse its position. It maintained it through 2017 when it notified plaintiff ahead of time that it would be financially responsible, all the way until it asked for an invoice from Preserve for the paver work. There's never once a shift or an agreement. Going back to the financial statements brought up by counsel, the financial statements, as referenced in the lower court, they're not a binding contract between the condominium and the unit owner that it ever agreed to pay for the paver, the removal, the storage, and the remediation of these paver stones. Nor does it preclude them from coming back to the unit owner and asking for the money that they're entitled to, because the unit owner is responsible for the normal maintenance of the paver stones.
So the co-op's notice to him that he would be held liable for the cost of replacing the pavers occurred long before any of the dispute about the elevator, correct?
Correct. So in 2017, the unit owner is then notified that they're responsible for these paver stones. I believe the record's clear that at some point in 2017, that's when the condo, this is after that notice went out, that in 2017, the condo comes to the unit owner, the plaintiff in this matter, asking to purchase a space for an ADA compliant elevator. Those conversations went on from 2017 and 2019 when his client ceased those conversations and indicated that he wouldn't be complying with that. But at no point during that time did the board ever reverse its position. It's always maintained that these paver stones are the duty of the plaintiff. And furthermore, the conversation about the elevator, the ADA compliant elevator, had no bearing on this project or whether or not the board would be seeking payment. I mean, that's clear based off the record. And if there's no other questions, I'll rest on my papers from the court.
Thank you.
Thank you.
Defendant's counsel said the condominium never reversed its position. It engaged in a course of conduct over the course of 2 years where it entered into a contract with the contractor, it paid for the work, it accounted for the work, and no, it's not a binding contract, but certainly a recognition by the corporation, by the condominium in the audited financial statements that this was not the responsibility of the unit owner.
Because they undertook the work?
But it was the responsibility.
Because they undertook the work?
But, I'm sorry?
Because they undertook the work.
No, that the condominium entered into the contract, and the condominium did not charge that work in the audited financial statements to the plaintiff.
Until later on.
Charged it to all of the condominium owners as a...
Right, but you're stating that indicated a change in position because they undertook the work. But why would that necessarily indicate a change in position when they had specifically stated that they would bill you, or that they could bill you for the work performed?
Your Honor, they didn't specifically say that they would bill us. They specifically said it was our responsibility to enter into a contract with the contractor for the removal of the paver.
And they never notified you that that position was no longer in effect, right?
They never notified, no.
So they didn't, I don't understand how whatever decisions they made about signing the contract and undertaking the work and reflecting it on their own internal accounting doesn't affect the fact that they had advised you that it was your responsibility, and they never deviated from that.
And the managing agent also advised us that the condominium was going to be responsible for the removal of the pavers. That was before. That was after I sent
having it done, but not necessarily for paying for it.
Your Honor, I would agree with you, not necessarily, but in this posture of this case, where you have a pleading that says the managing agent said that the condominium was going to be responsible for it. You have the condominium then entering into a contract for the work. You have the condominium paying for the work. You have the condominium accounting for that work as a common expense. And the fundamental rule of law that the pleader is entitled to all reasonable inferences based upon the facts. It's evident based on that there was we're entitled to the inference that when they said they're going to be responsible for it, and they paid for it, that they were going to be pay for it. But beyond that, it wasn't until long after that work was completed. It wasn't until after the whole roof project was finished, and only after my client refused to transfer the elevator space to the defendant, to the condominium, did the condominium say, oh, now we're going to bill you for this, and we're going to assess late fees of $1,000, confiscatory late fees of $1,000 a month.
Sure.
The allegations are that billing was in bad faith. It was a vendetta against my client for refusing to transfer the elevator space. And at the pleading stage, we are entitled to our day in court for discovery with respect to what really went on in that boardroom, what motivated them to ultimately bill 2 years later, as opposed after they had entered into the
Thank you
contract
very
themselves.
much. Thank you both. People v. DeShante Page.
Thank you, Your Honors.
Yes.
Good afternoon, it may it please the court. Paul Anderson for the people. So CPL 3030 addresses two distinct questions. When the people are supposed to be ready, and two, what exclusions are the people entitled?
So what periods are in, what periods are you stating were calculated incorrectly?
From July 28th, 2023, when,
July 28 to December 15, 2023.
correct.
So the court excluded 140 days.
The court counted 140 days. And because defendant's
Oh, I'm
motion-
sorry, the 42 days should have been charged, is what you're claiming.
Yes, the 140 days from when defendant's motion was decided to when co-defendant's motion was decided. And the reason for that delay was because co-defense counsel never complied with his obligations to serve that motion on the people. And he was directed twice by the court on June 13th and on July 28th to do so. And then the people reached out in September, filed their opposition within a week of getting it, and the court didn't engage with the people's arguments
The
that
3034D excludes time for motion practice for co-defendants or co-defendants unavailability.
It's 4D is for co-defendants, and then you rely on the co-defendants for A exclusion. So they work in tandem because, as the Court of Appeals recently held, there is but one clock in a joint prosecution.
So what was the court's basis for including that time?
So in the first decision, the court made no finding whatsoever. It just did a pure calendar count. So we moved to re-argue, and on re-argument, the court granted but adhered, but said that because the judge made a notation previous or indicated previously that he was going to charge the people for the delay in responding to co-defendant's motion, this defendant would be able to be entitled to that exclusion, but made no factual findings. And then later down the road, he excluded the time as to co-defendant.
So defendant argues that there should have been some due diligence or some attempt on your part to obtain the omnibus motion from the co-defendant.
And that argument is raised for the first time on appeal. It was not raised below whatsoever, so it's unpreserved. And also
Despite that, is there any support for that in the case law?
No, there is no support that the people have to act with due diligence to chase down or police defense counsel's motion practice. The due diligence requirement, I think, speaks to that first question I was talking about earlier about stating ready, doing all you need to do for discovery. And so here also, a popular case today, LaFontaine, because the court didn't rely on any diligence requirement, affirming on that ground also violates LaFontaine and Concepcion. But in any event, it's unpreserved, and there's really no record to develop it for there. So given all of that we had unrefuted sworn allegations saying this is why it took so long for us to get our motion, and that was never refuted, the court didn't engage. I guess it looks like the court just assumed that the exclusionary questions are conditioned on readiness or certificates of
Because
compliance.
you had not filed a certificate of readiness.
Correct. We did not file that.
So the next period, I think, is February 28 to April 3, 2024?
Yes. So for that, we relied on the exclusion that it was a defense requested adjournment because we made sworn allegations that Well, first defense said that he was there on that date with his defense client and that it was adjourned. We refuted that and said, on some made sworn allegations, that no, defense counsel sent an email saying he was unavailable to attend that day and requested a date in the future.
So your argument is that time is excludable despite the fact that you had not filed a certificate of compliance and statement of readiness.
Correct, Your Honor, because the sub 4 exclusions are not conditioned on the people's statement of readiness.
How many days do you calculate are chargeable to the people?
I think I had 98 total, Your Honor.
98?
Yes. I apologize, Your Honor. Because it was 140 overcharge, or that we contest charge for the motion practice, and then 36 for the other that it requested adjournment.
The time between when the co-defendant's motion was decided and the filing of the certificate of compliance, is that chargeable to the people?
Between when the co-defendants, yes, Your Honor, except for that exclusion between February 28th and when we, I guess, filed our certificate of compliance and statement of readiness 6 days later. So
March 5th or something?
yes, Your Honor.
Yeah.
So
From April 11, 2023 to May 3rd, 2023, right? That's when the defendant was arraigned. And on May 3rd is when the defendant was arraigned on the indictment.
Yes.
That's chargeable to the people. Correct?
yes, absolutely.
Okay. And from November 3rd, 2023 to February 28, 2024, that's also chargeable to the people, correct?
I would disagree between November 3rd when the motion was decided and December 15th, 2023
Why?
for hearing.
Is it
and
reasonable
trial.
time to prepare?
Yes, Your Honor. under
Does
4A.
do you get the benefit of that when you have not filed a COC and a statement of readiness?
Yes, Your Honor, because I think it would affect how to prepare for that COC, what becomes more encompassed, what doesn't. And
I'm sorry.
I guess there's no way to split the 4A, because that all comes under 4A to prep for hearing and trial, and I understand, and so there really is no mechanism to split that.
Well, I mean, you're arguing that you don't know what hearings are going to be granted, so therefore you don't know how to prepare for those hearings. But I'm not sure, when you file your certificate of readiness, it's that you're ready to proceed regardless of what hearings are or not granted.
Yes, and if there's a dispute about that, we could go into more of a hearing and develop the record of how that could have, I guess, changed how we're gathering discovery. And I understand we could file supplemental certificates along the way, but because
I don't
this falls under A, I know.
I'm sorry, and I don't mean to have him not answer your question, but I don't understand when you file your certificate of compliance and your statement of readiness, that means that you're actually ready to proceed at that time.
Yes,
What does it mean if you haven't filed it?
that you're not ready to proceed.
And so when did you file it?
March 5th, I think you said. So after,
So
yes.
then how would you be ready on December 15th to do a hearing?
There's no court, there's no case out there saying that you can split that 4A exclusion based on readiness. And I understand what your honors are saying, that you're saying
That 4A exclusion is automatic?
yes, it's with a reasonable time to resolve the motions, and that includes and has included, and there's been no case really bifurcating whether you're entitled to that exclusion or based on the certificate of compliance.
What
or
happens
readiness
if
or
the
not.
people never file a certificate of compliance and a statement of readiness? What happens to that exclusion then?
Then I think the next court date, people, are you ready to proceed? No, we're not. Okay, now the clock
Would
starts
all that
again.
time be included then?
No. Oh, I see what you're saying.
Yeah, it would be. I mean,
Yeah.
it would have to be because I think
yeah,
that
I see what
that period between the decision on the motion and then the next day, that the period where the court is considering a motion is excluded.
So yes, the period is excluded when they're considering the motion, but I guess the post-motion decision.
The post-motion decision. So now, if the court decides the motion on 2/28, then the next adjournment, you would have to have filed your statement of readiness, certificate of compliance prior to the adjourn date, right?
No, Judge, I think we would still be in time. And I'm understanding what you're saying, but I think
once the motion has been decided, then any time after that is charged to you until you file your statement of readiness.
I would
I don't know if
disagree.
because it's not, I can see what you're saying, that you're entitled to a reasonable time to be ready if you're in fact actually ready.
But
on
if
the
that's,
next
if you're
time.
actually ready, then there's really nothing to
Because
exclude.
if you never actually become ready, that doesn't run indefinitely. Like, how do we cut off that reasonable time?
Right, so that's why I think it has to be, once the court makes a decision on the motions, then any time after that, it's going to be charged to you.
I disagree, because I think the way that exclusion works is because if we were stating ready immediately after the decision was decided, then we wouldn't need the exclusion at all. So here,
Is that true? Because maybe the decision on the motions and the hearing didn't go as you expected.
I mean, but that's still the case here. Then we're still entitled to that exclusion if the hearing didn't go, or if the
Except that you had not answered ready by then.
Right, so again, so suppose the court renders its decision on February 28th, granting a map Huntley Dunaway, and then the matter is adjourned until 3/23. You're stating that you would be, in that time from 2/28 to 3/23 is excluded?
yes, and that has typically been how it's been excluded. And I
No,
think this
it's
court has-
typically, but I see the issue because there would be inconsistency, right? Between the Court of Appeals stating that you have to file your certificate of compliance, your statement of readiness.
It wouldn't be an inconsistency, because the exclusions apply independently of the readiness in terms of what the legislature decided to change. The legislature kept 4A intact, 4A through G intact, and only modified 5, which speaks to the actual act of stating ready and what you have to do to get to that condition. But if the exclusion applies pre-2020, it should apply still untouched as is. And so that time period between the motion decided in, I think it was November to the month and a half, or the month later in December, that still falls into the 4A exclusion. And if it was, and
Wait a minute.
I get we get into more into
Hold on
the.
a second. I was going to just ask you about that. So you're saying that from November 3rd, 2023, that it's excluded until when?
He said February 28th.
No, sorry, not February 28th.
You meant
The next
December.
adjournment.
You meant
did
December.
December 15th?
December 15th, which was the
Oh,
next
okay.
adjournment.
Okay, all right. That's better than what you just said.
Yeah, because you said February 28th, and I had that written down. I'm like, how is that possible?
No. Because
Okay.
I think because then that would go into whether that's unreasonable or not. And so I'm saying to the next adjournment to prepare. So the February 28th was more about whether counsel was present or
Yes.
for an adjournment. So that's the difference.
Thank
So
you. You have time on rebuttal.
thank you, Your Honors.
Good afternoon. May it please the court. Jordan Estes for Gibson Dunn on behalf of defendant respondent, and I'd like to introduce my colleague, Swati Sri Rangarajan, and request permission for her to participate in the appeal.
Thank you.
Thank you.
May it please the court. CPL 3030.
Wait, so counsel, let's talk about this reasonable time to be ready for the hearing. We know that the co-defendant's motion was decided on November 3rd. And then the next when was the next court date?
December 15th.
And on December 15th, were the people ready to proceed?
No, Your Honor.
So what do we do with that time between November 3rd and December 15th?
Your Honor, we argue that that should not be excluded for all the reasons you have been discussing. There was nothing for the people to be preparing for. There was no hearing. We were just waiting for them to be ready. So that should not be excluded, Your Honor. And if I may talk about the time before then, which is the case dispositive period between July 28th and November 3rd, we also think that time should not be excluded under Section 4D for this, as the court below decided. The purpose of the statute is to disincentivize delay, and Section 4D specifically says that.
How do you deal with the fact that the Court of Appeals has said that there's one clock?
Yes, Your Honor, we're not disputing anything about.
And there was a mechanism, if you wanted the court to treat your client separately, there was a mechanism to employ that, and you didn't engage it, did you?
Yes, Your Honor. So there's two safety valves to that one clock, and People versus Blue acknowledges that, and that is what is in the plain meaning of the statute as well. So one is the one you mentioned, severance. The other is that it has to be a reasonable period of delay. And the decision below was decided on that basis, that it was not reasonable for that time, for that period of delay, that the people claimed they were waiting for service. And so.
But it's the co-defendant's failure to file. What are the people supposed to do about that?
Yes, Your Honor. So the co-defendant actually filed the motion. They just did not serve it.
Well, that's a problem, right?
Yes.
So then it's a nullity.
Right, because motions are valid once they're filed and served.
So it's a nullity.
So we're not challenging the fact that the co-defendant failed to serve. The issue here, though, is whether that time is excludable as to a third party, Mr. Page, who at the time did not have the sufficient notice to move for severance because he did not know that this entire period of delay was on account of the service.
Was there any court appearances between the time defendant's motion for summary judgment, defendant's motion was decided and the co-defendant actually filed their motion?
No, Your Honor. So that decision was on July 28th. At that point, it was adjourned for the people to file a certificate of readiness.
So it was adjourned to November?
It was adjourned to September 29th. And on September 22, the people asked Mr. Selby's counsel, where's this motion? I need to oppose because we have a court date coming.
So the people were served on September 22nd, right?
Yes, that's correct.
And they filed a response, and there was a decision had by September 29th, the next court
They
date.
filed a response on September 29th. The decision happened on November 3rd.
You're right. That there was another right. The court needed but the people so they turned around and filed a response in 7 days of getting served.
The co-defendant's properly served motion.
Yes, Your Honor.
So how is there any lack of diligence or any attempt to, they turned it around quickly. How are they delaying the proceedings?
But their duty under the statute is not simply about responding to the defendant's motion. To the extent they want to rely on the single clock that they joined these two defendants under, they have a duty to the other co-defendant to let them know if there's a delay being caused.
Based on what? Is there any case law, anything that states that there's any duty on the people to notify counsel or co-counsel as to motion practice?
Your Honor, I don't have a specific case on service.
Why isn't the duty on his counsel to follow up with what's going on with the co-defendant's case, knowing the state of what the law is?
Your Honor, so if Mr. Page does not have any notice that the people are waiting not to be ready, but for
Sure he does, because wouldn't co-defendant also be served with papers?
Yes.
You're going to be, you serve co-counsel as well. All counsel is served. So at some point in time, Mr. Page would know that that the co-defendant has not filed motions because he hasn't received them.
Yes, but Your Honor, the statute does not put a duty to be ready on the defense counsel. The duty is on the prosecutor.
But that's not I don't know does that go to readiness or does that go to the fact that the co-defendant has not filed motions?
What if the co-defendant never files a 30-30 motion? What happens then? They got the motion scheduled, they don't want to do it.
Well, an omnibus motion.
Omnibus motion, I'm sorry.
Not a summary judgment. It's an omnibus motion.
Did I say summary judgment again?
No, you
I'm
you
so
said 30,
sorry.
30.
This is what happened.
There are too many motions, obviously.
But yes.
Yes, Your Honor.
Omnibus motion.
Again, this is not that the people committed a violation, but rather if they decide they want to benefit from a statutory exclusion.
You're saying there's a heightened responsibility on the people when they decide to charge defendants together?
I'm saying that they have a duty to ensure that that if there is and this is a pre-readiness period. So if there is something on the record that speaks to the reason for the delay, they have a duty to clarify.
So if the people had in fact filed a statement of readiness after the receipt of the motion, would there be an argument that it was illusory, that they could not have been ready because there were no motions by the co-defendant?
I'd have to think about that, Your Honor. So if they had...
I was just thinking about that.
So if they...
Because I could see a defendant saying, well, obviously it's illusory because you couldn't be ready because motion practice has not been concluded.
Yes, Your Honor. Although I guess that motion practice doesn't really speak to their readiness as to Mr. Page.
But they're not severed. There's no motion to sever the defendants, and they're charged. I'm assuming all of this is because they're charged acting in concert.
That's right, Your Honor. But if they'd filed a certificate of compliance, then there would be more notice to Mr. Page as to why they're not moving forward.
But then Mr. Page, as I stated, would say that that was illusory as to the co-defendant.
Yes, that is an argument.
How many days is it that you believe should be charged to the people?
We count 272.
272. Thank you.
You're close.
Yeah, 272 versus 98. and the applicable period is 183.
That's right. But I want to make sure the court understands this is not People versus Blue. This is a decision under reasonableness, which is within the sound discretion of the trial court. And so we ask that you affirm. Thank you.
Thank you.
So I'm just going to address two quick things, then jump back to our discussion earlier. Defense.
We only have 2 minutes, so.
I'll be quick on the first part. So defense doesn't actually have to move to sever. That was the whole point of Blue. In responding to the 3030
They
motion.
did not.
No, they did not,
Right.
but they don't have to. They could say there's good cause to sever, and that's sufficient to defeat.
And you can sever for purposes of motion practice.
Yes, but even
Yeah,
but
or
even
the hearings,
but
yeah.
even you wouldn't actually have to sever it. You could just say there would have been good
make the
cause.
argument.
Just make the
yeah.
argument. That's Blue. And so yeah, I guess just to return to the point that preparing for hearings and trial part of 4A shouldn't be conditioned on the people's ability to state ready on the next adjournment date or whether they stated ready previously. And I think Your Honor just pointed out that yes, if we try to state ready or too early, it's illusory and it kills
Yeah,
your
that's when you
credibility.
used to state ready at arraignments.
I was ready. Night
You were
already.
ready, yeah, right. Yeah, and then
AR3,
if
I
I
was ready
sent
with.
you out for trial, you would, all of a sudden, you were not ready.
I was ready with you, Your Honor, and I was ready with you in AR3 and 4 on the
Yeah,
weekends.
you were always ready. Yeah, you didn't know who your witnesses were, but yeah,
I
you
had-
can't send me out to trial. Oh,
UC
they were in the bank.
221, let's go. But yeah, so that should we should be entitled to those exclusions. And in terms of the other adjournment date that defense requested adjournment, they requested that adjournment. That should have been excluded. And in fact, a lot of that delay happened.
See, you know, in terms of that date, counsel was not, either counsel was present or not present, but he stated that he was not going to be available.
He wrote a letter to the court saying that he was unavailable and that he could find no other counsel to appear.
Yeah.
And if the people aren't ready at that time, why should that be chargeable to defendant?
It's still, that's
Or why should it be excluded?
because I guess because the exclusions apply independently of readiness.
For unavailability, unavailability of counsel.
For 4F for unavailability of counsel, and also the I forgot the subpart, but the counsel requested adjournment, and so there was a real live issue of fact of whether counsel was present or not until on re-argument they conceded, oh, I wasn't present. Here's my email. So if Your Honor have no further questions, I've taken a lot of your time.
Thank you.
I just ask you reverse.
Appreciate it. And thank you for doing this pro bono. Appreciate it. Thank you very much. Berardi v. 900 3rd Avenue.
Good afternoon, Your Honors. May it please the court, Kristen Carroll of Wilson-Elser for third-party defendant appellant Empire Office. We respectfully ask this court to modify the lower court's decision because it erred first in considering plaintiff's improper untimely cross motion and second in granting his motion for partial summary judgment on his Labor Law 241-6 claim premised upon Industrial Code 1.7E1.
One of the issues here is whether or not this was a passageway.
Yes, Your Honor.
Have you seen the picture in the record?
Yes, Your Honor.
Okay.
Pages 596 to 601 show the photographs in the record. And with respect to that issue, Your Honors, although the regulations do not define the term passageway, courts have interpreted the term to mean a defined walkway or pathway used to traverse between discrete areas as opposed to an open area. The testimony in this case, as opposed, in addition to the photographs and case law, demonstrate that at least there is a material question of fact as to whether the area was a passageway or an open area under the Industrial Code. On the day of the accident, plaintiff was laying down tracks.
Except that the area that was in question was a corridor. Why isn't that classically a passageway?
Your Honor, one witness testified that it was a corridor. However, the photographs of the area show that the office spaces were not yet built out. This was an open working area, and plaintiff was installing tracks that would put the glass to build out the office spaces.
Where the tarp, I don't know, the blue material, where it was laid down, was inside a corridor, like that specific pathway.
Not yet, Your Honor, because there was not yet a wall on the other side to render it a corridor. But irrespective of whether a witness testified that it was a, quote, corridor or whichever way they choose to characterize the space, Your Honor, there is enough evidence that a question of fact exists. And I point this court to this court's case in Provost v. One City Block, where the court held that there was a material question of fact as to whether it was a passageway or an open area, where the plaintiff described the area as a corridor and the superintendent conversely testified that it was an open space. Similarly, in Krasansky v. New York, City of New York, this court held that masonite boards that were removed from the site on a daily basis raised issues of fact as to whether the boards were simply a protective covering.
That may be in that other case, but I'm looking at the photographs now, and
Here are the photographs.
it's
I mean,
clearly,
it looks like a corridor, like it would constitute a passageway.
I mean, the offices aren't built out yet, but it's clearly a corridor between the locations where the offices are
Right,
being
you have
built out.
you have some built out on one side, but it seems clear that that's a passageway.
Your Honor, there's a frame on the left side of the photograph. The glass was not yet put in. If there were walls on either side, I would agree with Your Honors that it would
Was
constitute.
there anything in the record, or does there need to be anything in the record showing the alternate pathway that could have been taken?
No, Your Honor.
No, there wasn't anything there, or you don't need to show it?
We don't need the alternate route with respect to what issue, Your Honor?
Well, if it's, how else would he have gotten to wherever else he
Oh,
needed to go?
I apologize, Your Honor. Yes. Gannon's witness testified that there was another route that plaintiff should have taken, demonstrating that this wasn't the only route that plaintiff could have taken to do his work, that there were other ways to get to transport the glass throughout the floor. This was not the only route that plaintiff needed to take to do his work.
But I
I
thought
mean,
that-
go ahead.
go ahead.
Where the tarp is laid down adjacent to it, there is framing materials for where the office is going to be, and obviously it would be far worse if he had taken his cart filled with glass over framing that juts up several inches. Are you really suggesting that that's not a passageway between the two units of framing?
Right, I thought that the testimony was that he was going from one location to the other location, and that's why he was taking this path. So there does not appear to be another path that would lead to where he was going.
Your Honor, the testimony, there was conflicting testimony as to whether plaintiff should have taken that route depicted in the photographs or
Who testified as to another route?
Gannon's witness, Your Honor, testified that.
Where was that route?
Chris Richardson, that person?
Yes.
Who was this?
Gannon's witness testified that there was a different route that plaintiff,
What was that route?
a different route within the floor, Your Honor. This was a big open floor. They were transporting from the elevator.
It's not open. I'm having trouble with this, but go ahead.
Your Honors, if it was flanked on either side by a wall or by some sort of object, I would agree
Are you
that it
saying
was.
that the alternate route is, instead of going straight, you sort of curve? Is that what you're saying?
Yeah, I'm looking at the
That makes no
testimony, I'm
sense.
not sure that is what he says.
Is that what you're saying when he said that he should have traveled over a path where masonite was placed over the tarp?
Correct, Your Honor. So that demonstrates that
It
there.
means not straight around it.
Right.
So going back and forth as he came out of the offices that were done or not done.
I'm sorry, Your Honor?
So he'd be going back and forth through the offices that weren't completed so as to not be on the tarp?
It demonstrates that there are different ways that plaintiff could have taken.
But
But
is it
he
a
wasn't
rational way?
instructed to go in a different way.
That's
You see, he acknowledged, I think you're talking about Richardson.
Yes.
Richardson acknowledged that he did not instruct anyone from Empire as to a specific route to take with the new glass panels. He also acknowledged that no one from Gannon had told him to block off the route plaintiff and his coworkers were using on the night in question. You have time on rebuttal.
Thank you, Your Honor.
Good afternoon, Your Honors. C. Briggs Johnson for the main defendants, respondents. I think there's also a procedural issue on this appeal, which was that we never moved for summary judgment. And the rule is in this department that if you don't move for summary judgment, you can't cross-move for summary judgment against a non-movement, right? And that's the Kershaw case and the Sandoval Morales case, decided in 2024. Moreover, when you make a late summary judgment motion, part of your prima facie burden as a movement is to establish good cause.
So you're saying procedurally plaintiff never moved for summary judgment and therefore we shouldn't consider it?
I'm saying part of the prima facie burden in your moving papers is to establish good cause. You can't raise good cause for the first time and reply, just like you can't raise your prima facie burden for summary judgment under the labor law or for contractual indemnity for the first time and reply. When he cross-moved, he didn't even talk about it. He just pretended that the timeliness issue was not there. The first time he raises the timeliness argument is in reply.
So are we able, in our discretion, to search the record and grant summary judgment to the plaintiff?
Not against the not against the non-movement.
Really? So CPLR 3212B?
CPLR 2215 and the Kershaw case and the Sandoval Morales case say, and I'll direct quote it from this court, the rule is that a cross motion is an improper vehicle for seeking relief from a non-moving party. That's Kershaw 114 AD 3rd 75.
Well, was it really a cross motion, or was it just kind of mislabeled as a cross motion?
No, it was a cross motion. I mean, and it was late. So
But it's a motion. It was a motion for summary judgment on the 241-6 claim, right?
Correct.
Okay. And who is it? Empire.
Empire moved for summary judgment.
Right. So it's the same. So it's almost identical to Empire's.
I'm not going to argue against the fact that he's moving under 241-6 and Empire
Only because
moved for
there's a
dismissal.
case, Durama v. 902 Liberty Avenue Housing Development Fund, here from 2018, which states that because it's nearly identical, we could treat it and we can address it. And also under 3212B, we can, in our discretion, search the record.
Understood, but I think we never moved for summary judgment. So, you know, he's trying to improperly backdoor a late motion for summary judgment against a party that never moved, right? And so I think CPLR 2215 and the Kershaw case and the Sandoval Morales case control on this issue. Also, you know, if we want to go to if I can go to the merits quickly, there is the testimony from plaintiff and from Gannon regarding the chain of construction argument is that there's no tear in this tarp until after the accident. Plaintiff himself said he walked across the same area of the accident 10 to 15 times, that there was no tear in the tarp, and that the first time he saw this was after the accident. So there's issues of fact whether someone within the chain of construction was negligent and not acting within a reasonable time to either identify or remedy the hazard. And that's case law on point A of the brief. I'm sorry. That's the Joseph case, 244 AD 3rd, 594 First Department 2025. The Cavedo case, 217 AD 3rd, 567 First Department 2023. There's actually no proof of a defect until after the accident. So to find a violation of 241-6, when we only have proof, you know, of any defect at all, not until after the accident, that requires jury deliberation, in our opinion. I thank you for your time, and I'll rest on the arguments in my brief.
Thank you.
Good afternoon, Your Honors. Jason Levine for the plaintiff respondent. First, I'll just touch on the issue of the passageway. We would submit that as the motion court properly found, the testimony and the photograph prima facie established that this is a passageway within the meaning of the code. It's a designated pathway, as evident from these photographs. It was the manner in which these workers were taking these A-frame carts to and from, whether it be the elevator, and to transporting them to the various offices to build out the space.
Was there anything in the record, I guess from Richardson, who detailed what exactly the other alternate path would be?
Right, he never testified that they were. He specifically testified, I think, as you pointed out earlier, Your Honor, that he never gave any instruction that they weren't supposed to use any of these particular paths or any area was barred from walking on, such as the path that the plaintiff took. In addition, I would point out it's not the onus of the worker to find a safe place and a safe passage in order to work. That's the responsibility of the owner and the general contractor.
There was just from your adversary that the rip was not present until after the accident. Therefore, I'm assuming that's going towards notice. What's your response to that?
Well, I would submit notice is not an issue on this because, in any event, I dispute that testimony because the testimony, I believe, from Richardson and the plaintiff, they both positively identified these photographs and the tear and the rumpled up nature of this tarp as appearing at these, reflecting the condition at the time he fell. And I believe that's the plaintiff's testimony in particular, which I believe Richardson also did not dispute.
Can you address the issue of whether the tarp was integral to plaintiff's work?
Sure, Your Honor. We would submit that that doctrine doesn't apply in this case because the torn tarp is not integral to the, it's not inherent in the task that the plaintiff was doing. I would submit that arguably, if there was masonite that was put down, which it was supposed to be, right? That's the manner in which it was supposed to be safely transported, these A-frame carts to transport the glass, then maybe that would apply if there was a defect in the masonite. Here, though, the mere fact that the tarp is there, that's not, that under the case law cited in our brief, it's not applicable to this.
Well, the tarp seems to be an inherent tripping hazard anyhow, because it is rumpled. And if you're going to continue to move A-frame carts, it's just going to create more of an issue.
Especially if they
Well,
carry.
the issue here is,
Especially if they're carrying glass. So I'm not even, I don't even understand the tarp. At some point, there is masonite over the tarp at some position, which kind of makes sense, but this makes absolutely no sense.
well, exactly, and I think that supports the motion court's conclusion to award plaintiff summary judgment on the 241-6 claim. And again, if I can touch briefly just on the procedural issue about the cross motion, its timeliness, et cetera. Again, as Justice Weber, you pointed out, I mean, arguably we could have not moved at all and just asked the court to search the record. I mean, the critical issue here that the motion court had to decide was whether or not there was a violation of 241-6, in particular, the Industrial Code 23-1.7E1, whether we cross-moved or not, made a motion. Again, the court could have searched the record. This court could search the record even if it finds that the motion court should not have affirmatively, entertained a cross motion per se, but we would submit that the motion court was within its discretion to award that relief. Unless the court has any further questions, we'll rest on the arguments in our brief.
Thank you.
Thank you.
Your Honors, a few brief points on rebuttal. With respect to Your Honor's question of the purpose of the tarp, it goes to the integral part of the work. Multiple witnesses testify that the tarp was laid down to protect the recently laid carpet underneath, and this court's...
You could have used other materials than the tarp to protect the rug underneath, which would have been less dangerous, certainly.
Yes, Your Honor, but when we're considering whether it was integral to the work, whether it was tarp or a different material, it was still used to protect the flooring, which was integral to the overall renovation project.
Integral to the work also means that it's an appropriate way of doing whatever it's supposed to be doing, and which in this case was covering the rug. And the appropriate way to do that would have been with a safe surface, which they had available to them and chose not to use.
Your Honor, there's no evidence on the record that the tarp was unsafe. The plaintiff...
Did you look at the pictures?
Your Honor...
Look at the pictures and you can see that the tarp was unsafe.
Your Honors...
I mean, obviously, it's not laid down flush, right? There are rumples in it. And by having carts going back and forth over it, and people just walking.
That are carrying 300 pounds of glass.
Yeah, it's going to be an issue.
Yes, Your Honor. There's a difference between ripples and a 1-foot gap, and plaintiff's testimony was clear that there was no gap. He did not see any gap before he walked over this area 10 to 15 times with that cart, which goes to our point that there is no issue. There is issues of fact as to whether someone in the chain of construction was negligent, because it's reasonable that the tarp ripped because of plaintiff's fall, and it was not ripped before.
Thank you.
Thank you, Your Honors.
Sherry V. Hogan.
May it please the court. Ira Jubin from
Move the
Gibson.
mic a little bit closer, maybe? Yeah.
Thank you. Ira Jubin from Gibson Dunn on behalf of Appellant Richard Hogan. The decision below represents a sea change in New York trust and matrimonial.
It's interesting that you say it's a sea change. What about the case of Reichers, in which the Second Department approved the trial court's decision to include in the marital pot the value of funds placed into an irrevocable trust, and the Court of Appeals denied leave to appeal. So it seems to me it's not a sea change, it's just a little ripple.
I think Rikers is very much distinguishable from the facts of this case and fits and actually illustrates the rule that is normally applied. So in Rikers, there was a Cook Island trust, and both the husband and the wife were beneficiaries during the marriage. And then after the marriage, the wife was out and the husband was still in. And that's one of the classic.
That's essentially what happened here, counsel, in practice. They were both, during the marriage, they were both able to use, for example, some of the assets in the trust, which were their vacation homes. And as soon as she commenced the divorce action, miraculously, the trustee excluded her from those homes. And the husband continued to use them at a vastly, for a lease at a vastly reduced price. So in practice, once the divorce began, she was excluded. How do you address that?
So Justice Gesmer, that's a critical question, and thank you for the opportunity to address it. The trial court did rely on that, but the reasoning there is not correct. So what happened is that those houses, both Hogan's Hill and Shorewood Court, Mr. Hogan had a personal ownership interest outside the trust of those for most of the marriage. Through 2016.
I'm sorry, as to the Hogan's Hill house, he had a premarital interest, but as to the other houses on Shelter Island,
Shorewood Court,
he had no interest other than that acquired during the marriage, which is clearly a marital asset.
It was a marital asset, but not a trust asset. He had a 1% interest in Mont Blanc, and Mont Blanc was partially owned by the trust and partially owned by him.
And you think it's just a coincidence that when the action for divorce was filed, that the trustees suddenly decided that she should not be able to use that home anymore?
So it's not a coincidence. What happened is this, and I think the chain of events is very important on this. In 2016, the parties entered into leases for both Hogan's Hill and Shorewood Court because he had finished his personal interest in Hogan's Hill, and they entered into these leases. In 2020, Miss Sherry had an alcohol-related incident that resulted in her loss of parenting.
His exclusion of her from the house had nothing to, there's nothing in the record that suggests that his exclusion of her from the house had anything to do with her alcohol problem. And in fact, it's interesting to me that he didn't testify about the alcohol problem, but just put in various documents, some of which look like hearsay to me, and don't really establish any connection between those two sets of events that you're trying to link.
So A1762 and through A1764 is a so ordered stipulation by the court.
Yes, I read that. And that does not discuss her alcohol problem. It says that they have use of the home when they have the children with them.
Respectfully, that stipulation talks about her alcohol abuse, and it talks about a new monitoring program going into place, and in exchange for her restoring parenting time with the children.
But it doesn't connect that to the trustee's exclusion of her from the home, which occurred before that.
So A1765 says that she'll vacate the properties because of the alcohol abuse issues. And I think just stepping back a little bit from this factual record, because that is the factual record that this was pursuant to a so ordered stipulation, at most, all that would show is that $207,000 in a benefit to Mr. Hogan that Ms. Sherry didn't retain. And a $207,000 benefit each year cannot possibly justify putting $111 million in trust assets back.
What about his decision to transfer all of the trust assets from, I think it was the GST trust, to two trusts in Delaware while the trial was going on, without her consent, without the courts, without advising the court, in clear violation of the automatic orders?
So it was the trustee, not Mr. Hogan, who decanted the trust.
Yes, I'm sure that's what happened. I'm sorry, there's nothing I've seen in what I've read of the record so far, and I don't claim to have read it all yet, that suggests that there was much light between Mr. Hogan and the trustee.
So the trustee is the one who decanted the assets, which is the answer to the automatic orders problem. But just, again, step back for a second.
He also didn't testify. There's no evidence in the record that that was his decision.
Well, he was the trustee. He was the one who did all of it.
I know he was the trustee, but the question is how it happened that he did that. And it seems to me that Mr. Hogan's choice not to have him testify that those were his decisions and his decisions alone is rather telling.
Well, I think, Justice Gesmer, the critical point on this is that Ms. Sherry has no argument and never tries to make an argument that that decanting somehow gave Mr. Hogan a personal benefit. It didn't. It was a move for the benefit of the
But
beneficiary.
decanting happened at the end of the trial. I don't understand how she could have put on evidence about it at that point.
Even in her briefs today, there is no argument on this because the reason for those decantings and the reason the trustee did those decantings was for the benefit of the beneficiaries to take advantage of new tax exemptions that came out in 2017. But the point—
Was that stated in the record?
Mr. Hogan testified to that, and Mr. McCabe testified he had advised them about that, to do that in 2017. But the critical point is that for purposes of whether assets are marital or trust assets, you have to look to whether the assets belong to one or both spouses and whether they have a beneficial or economic interest in it. And nothing about the decanting of the trust establishes that Mr. Hogan had any sort of belonging, ownership, or economic interest in the trust asset.
Right, but the beneficial interest in the trust is indicated by the fact that he continued to have below-market rentals, leases for several of the homes where she was excluded from them. That it certainly indicates a very different allocation of the beneficial interests.
So again, I would refer you back for that point to A1765, which says that she would vacate those homes and that in exchange that Ms. Sherry would be able to rent a vacation home.
I've read those pages.
For $30,000 a month. And in the end, all that comes down to, and this is really, really critical, is that if you think that is the right way to read the record, is that he benefited to the tune of $207,000. The way that courts deal with it, that's D'Amato and Van Dude, is by valuing that interest and distributing it, not by saying the entire corpus is now marital.
So your argument is that although she was excluded from that property, she received something that was comparable to that?
She rented another vacation home, and that's how she dealt with it, and that was dealt with on A1765. But even to the extent you found that there was some economic benefit that Mr. Hogan retained and Ms. Sherry lost, the amount of that benefit is $200,000 a year. It is not $111 million in trust assets.
And again, as to the decanting, how is that not improper?
So the decanting was handled by the trustee and not by Mr. Hogan, but even if you disagree with that—
Well, I mean, because again, it appears that although that your client had may be manipulating the trustee, or at least is directing the trustee as to what to do or what not to do.
Yes, and I think Justice Gesmer was raising exactly that same possibility. I don't think there's any evidence in the record that suggests that that is true. But the answer to that, if you believe that to be correct, would be an issue between the beneficiaries and the trustee, where they would be saying that the trustee is not properly exercising his fiduciary duty. But in fact, these decantings did benefit the beneficiaries, and there's no evidence in the record and no argument that they benefited Mr. Hogan. They did not in any way return the trust assets into the marital pot. That's the problem with my friend on the other side's argument.
Thank you.
Good afternoon, Honorable Justices. My name is Lawrence Greenberg for the respondent. Never before has a court been faced with the grantor of an intentionally defective grantor trust who abused the trust form for his own benefit to the detriment of his spouse. And while the trust—
Well, your client benefited as well. She's benefited throughout, right?
Well, the parties funded their marriage, and there was a legion of evidence adduced at trial to show that the parties' entire lifestyle benefited from the trust assets.
But there's no indication that it was defective, right? That there's anything defective with this trust.
This trust is an intentionally defective grantor trust, Your Honor, where the grantor of the trust retains certain grantor rights, such as the right to substitute property. Under 26 U.S.C. 675, the Federal Income Tax Code, the parties remain the owners of all of the trust property in such a trust. Therefore, as a matter of law, aside from these assets being marital property acquired during the marriage, notwithstanding the fact that they have been placed in such an intentionally defective grantor trust, the Internal Revenue Service under federal income tax law deems the grantor to be the owner of these assets.
And that explains why both of the parties included them on their net worth statements that they submitted to the divorce court.
That is correct. The net worth statements of both parties that personally listed their assets included all of the trust assets. So as of the date of commencement of this action, both parties took the position on their income tax returns that they were the owners of these properties. Accordingly,
Mr. Greenberg, can I ask you, in light of Hoffman, what is your theory as to why the assets in the irrevocable trust can be deemed marital assets?
under Hoffman, which my colleague only cites part of the holding, Hoffman held that the assets placed in an irrevocable trust are no longer part of the marital estate where the parties have relinquished all control and benefit. This is clearly distinguishable. Mr. Hogan continued to lord over $120 million of marital assets that were in this intentionally defective grantor trust, which I might add, as a matter of law, one, were marital assets, two, the case law, Yerushalmi and Torkin clearly state that transfer of marital assets to a trust does not rebut the presumption of marital property. And three, not only was he deemed the de facto trustee, but pursuant to Mahoney Buntsman v. Buntsman, he took the position along with Mrs. Hogan that he and Miss Sherry were the owners for all purposes. Also, while Section 671 clearly states that one result of this type of trust is being an owner, it doesn't limit the meaning of that result. Maturin v. Commissioner, 84 Tax Court 667. Similarly, in Sage
Greenberg,
v.
I would appreciate if you would address some of the mathematical calculations that are addressed in Mr. Hogan's brief. For example, his claim that in valuing the assets in the trust, the court didn't include the trust promissory note to the husband as of the date of commencement, but then treated as an asset the resulting $30 million in non-trust assets. So essentially, they counted it twice.
Yes, that
What's
is
your view of that?
That is completely devoid in the record below. Mr. Hogan did not offer any evidence, any promissory notes, any proof of repayment, and also, Your Honor, respectfully, during the course of the parties' marriage, many of these debts that were due from the trust to the parties or vice versa were forgiven. So the only document for which my colleague relies on is the net worth statement filed by Mr. Hogan, who was found to lack credibility on the core financial issues of this case. I might add, the net worth statement that he stated he did not sign or could not testify as to its accuracy. That is in the record at, oh boy. I believe A1248. I would also add, Your Honor, that Justice Waterman Marshall recognized that Mr. Hogan didn't comply with the trial subpoena. Some of the information requested on that trial
The client didn't move to compel or do anything else at that point, right?
Well, that was mid-trial. She did not. But what she did, what the judge did, is as a result, which included, by the way, Judge, Ms. Sherry asking for proof of any promissory notes, any alleged repayments of promissory notes, or any monies that went to Mr. Hogan. My colleague asks this honorable court to take Mr. Hogan at his word without any proof whatsoever of the existence of a $31 million payment. If there was a $31 million payment, where was the evidence adduced at trial? There's nothing in the record below. I would also respond to my colleagues.
Could you address the attorney's fees? Given the magnitude of the award that Justice Waterman Marshall gave to Ms. Sherry, why should we sustain the award of attorney's fees?
Your Honor, respectfully, the relative merits of the party's position in this case was extremely disparate. Mr. Hogan was found to have been guilty of egregious economic fault based not only upon the positions that he took with respect to his control and benefit of the trust assets, but his numerous violations of the automatic orders and on top of all that, he was clearly deemed to be the more moneyed spouse. Aside from
To the extent of $1.6 million in attorney's fees?
Well, Judge, in this particular instance, a vast majority of those attorney's fees were to combat Mr. Hogan's positions that lacked merit. Also,
$1.6 million?
that was 75% of the legal fees incurred by Ms. Sherry. And as the statute provides, in the first instance, while it's a rebuttable presumption, the more moneyed spouse is responsible for all legal fees in a matrimonial matter. Mr. Hogan had income of $2.8 million imputed to him, while Ms. Sherry had no income at all. I do want to also mention that this misleading statement about the custody agreement and Ms. Sherry's alleged alcohol use disorder, the custody agreement was entered into in January of 2022, A1762, that my colleague mentions. Mr. Hogan had Todd Stewart, his close personal friend, issue terminations of lease to him and his wife in 2020, on March 9th of 2020, thereby excluding Mrs. Sherry from the vast Shelter Island estate and the Hogan's Hill upstate New York property, only to have the trustee, and I use that term in quotes, reissue a lease the following day solely in Mr. Hogan's name.
Thank you. Thank you very much.
I wanted to return to some of the questions you were asking earlier, and particularly I think that Mr. Greenberg just hit on, which is this idea, and I think it does permeate the decision below, that the trust funded the party's lifestyle during the marriage. There isn't...
The trial court found that, as a matter of fact, and of course, normally we defer to the factual findings of the judge who heard the trial.
But of course, they can be reversed if they are wrong, and here they are. There is no evidence in the record that the trust supported the family's lifestyle. The trial court arrived at that.
Was there any evidence as to how the family's lifestyle was supported? I mean,
There
If
is.
there was no evidence of that, then it seems to me the court may want to draw an inference of where it came from. What evidence did your client present as to how the party's lifestyle was paid for, say, from the date of commencement until the trial?
So we discussed this in both our opening brief and our reply brief, but there's much evidence in the record, and this is A1960 through 1962, A11 through A13, and A1952 through A1964, which is what happened is that, and this is part of the trial court's order too, and I think shows some of the inconsistency in the trial court's order, the parties had $70 million outside of the trust, and they lived off that investment income. And so there's nothing sort of strange about where did they get money from. Like I do think where the trial court was coming from was, oh, he retired in 2001, so they must be living off the trust. But they had significant assets outside the trust, and they only transferred assets to the trust, even what they did transfer, over time.
And are there bank records introduced in evidence or any kind of record showing how the parties' living expenses were paid for?
There are all the account statements that, of course, the trial court relies on to say that there are $70 million outside of the trust. And there's the note that we were talking about earlier, the GST note, which shows that they had a $31 million note in which they were paid
Did those
interest.
show payments for the parties' living expenses anywhere?
The record shows that the account statements of them taking money out and paying themselves, and this is A1960, 1962, and A1952 to 1964, and that's all in the record. They also produced numerous other account statements to each other. But I think just to go to your point, what's really critical here is that there is not a shred of evidence that they ever withdrew money from the trust. He produced all the trust.
Is there a shred of evidence that it came from anywhere else?
Well, he produced all the trust account statements to Ms. Sherry. She has all of the trust account statements. And this argument was obviously a linchpin of the trial court's ruling, and we made our argument forcefully in our opening brief that there's not evidence on this. And in response, she has still never identified any improper withdrawal from the trust for personal expenses. There is not any evidence showing that they ever took money out of the trust for personal expenses. The money came...
Evidence was submitted as to any and all transfers from the trust?
The trust account statements were produced in full.
The trust account?
Yes, and there was never any evidence that Ms. Sherry has...
In evidence?
Apologies.
All of them are in evidence?
They were produced in full. They're not part of the record on appeal, but they were produced in full to Ms. Sherry. And again, she has never identified anything in any of those account statements showing an improper distribution. And the critical point is that they both had much money outside of the trust, considerable wealth, tens of millions of dollars, and the assets they transferred over time to the trust were done A, over time, and B, in exchange for a promissory note that paid them principal and interest in substantial amounts. And that brings us to really what the trial court is really looking at is really the fair market value of these leases that we talked about earlier. That's the only concrete thing that she points to that there is any evidence in the record.
Others, but you're right, she certainly discusses that.
Thank you. Thank you both.
Thank you.
People v. Michael Brooks.
Good afternoon, Your Honors. May it please the court, David Bernstein on behalf of Michael Brooks. Mr. Brooks should receive a new trial because the court improperly allowed the prosecution to introduce the 911 call and hearsay evidence about what happened, where and when it happened, who did it, and where the perpetrators went afterwards, all of which corroborated the state's two key witnesses, Mr. Ortiz and Ms. Garcia. Most critically, where Ortiz and Garcia provided the only evidence that a gun was brandished during the robbery, these errors were deeply prejudicial. So I'd like to just focus my argument today on the 911 call in particular, and specifically Ortiz's remarks that, among other things, he had been robbed at gunpoint. There's no dispute that this is hearsay evidence, that his statements in the call were hearsay. But they were not excited utterances because Ortiz had the capacity to reflect or fabricate and therefore was not operating under the stress of the incident at the time he made these statements.
That he had that capacity to fabricate?
I'm sorry, Your Honor?
What evidence is there to indicate that he had the capacity to fabricate? I mean, the 911 call, we've all heard it 1,000 times, right? The 911 call was placed, I think, within about 5 minutes of the incident happening. The caller was still following the perpetrators that had just robbed him. Why couldn't one infer or conclude that he was still under the stress of the event?
So a couple of things there, and I'd like to unpack them one at a time. First of all, I am glad that Your Honors have listened to the call itself, because even the parties below acknowledged that the complainant does not sound particularly excited.
It doesn't sound like the world is ending.
Right.
But that doesn't mean he's not under the stress of the event.
Correct, and we're not saying that that's the only factor that matters here. I think when you listen to that and then look at two other factors, I think in totality that's what we are talking about. The first is the fact, as Your Honor referenced, that there was this delay, and the record is not clear as to how long the delay is. Let's assume it's a couple of minutes. It could have been a little longer, but let's assume it's a couple of minutes. There was some delay during which Ortiz and Garcia conferred about this plan to follow the perpetrators and to wait until they were so far away that they would essentially not be able to see them following them. So there was time.
Where do you get that they conferred? I'm sorry. Where do you get that they conferred?
Well, okay, the record doesn't talk about a conversation in particular, but there was a delay where they were waiting for the
delay. The delay. If this was a present sense impression, the delay is huge, right?
Right.
It's not.
Well, respectfully,
I mean, it still matters.
I mean, and they had just been robbed by gunpoint.
Yes.
And they are going to follow the individuals who robbed them at gunpoint. I mean, it's this. Are you implying that they needed to be right behind them? Why wouldn't they wait for a delay?
Not at all, Your Honor, but the point here is whether Ortiz had time to reflect on what he was saying when he called 911. And I want to say that to the extent that I actually want to back up for 1 second and just say that this court has found that 2 to 4 minutes alone is sufficient time where there's an intervening event such as this.
What's the intervening event, though? Because it's still like they were following the people who robbed them so that they could describe them to the police officer. What's the intervening event?
There was some delay of some minutes where they waited for these people to be almost out of sight before they started to follow. So that is some deliberative effect. The other point I want to make is that in the call itself, Ortiz does not mention that he recognized one of the participants in the robbery, which he testified he did in fact recognize one of the participants. That shows a deliberative capacity. And the question about excited utterances is whether he had that deliberative capacity It's not an absolute, right? It's
I'm sorry, how does that show deliberative capacity?
Well, as the Court of Appeals has held in Cantavi, and this court held in Stewart last fall, where a declarant omits potentially important information from the statement that they are making, that reflects an ability to reflect on what they are saying, such that there could be an opportunity for fabrication.
Because I thought that those cases, there were other circumstances involved.
As there are here, Your Honor. I mean,
Yes.
again, there's a several-minute delay, which this court found in Robinson 2 to 4.5 minutes was a sufficient delay. Where in that case, the declarant, I believe, called her mother before calling the police in 2 to 4 minutes.
Right.
That is a
but
comparable
That's
period.
not what we have here. We have someone who is going to pursue the people who robbed them so that they can.
Who conceivably still had the weapons on them, and who had just been robbed did not have any weapons on them. Not that they should have. But I mean, they're going after folks who just robbed them at gunpoint. So again, why would you don't want to be right, on their tail, because they can conceivably turn around and shoot you.
Absolutely. I'm not saying it was unwise for them to wait. I'm saying the question for excited utterances is whether there was time to think.
But the time spent, if the time between was time spent deciding how big of a gap they should leave between them and these armed men, it seems to me that wouldn't decrease their degree of excitement.
Well, I think in totality, I think it does decrease their time because it shows that they they're processing this situation in real time and deciding what to do. I understand Your Honor's points, and I think, again, it is in totality. When you listen to the call, when you look at this opportunity to think about what they were doing, and then you look at the omission in the call itself, it would be a natural reaction for someone calling 911 to say, I recognized one of the perpetrators. That did not happen here.
Unless you're too excited.
Sure.
You have time on rebuttal.
Thank you.
Good afternoon, Your Honors. Sylvia Wertheimer for the people.
Counsel, I don't know that you would agree, but from listening to the 911 call, it seemed to me that, and I'm not saying he wasn't under the stress of the event, but there was no excitement in his voice. He was as collected and calm as a person can be.
Well, I disagree, Your Honor. The court below specifically rejected the characterization that he was calm and collected. And I think
What evidence is there that he wasn't? I mean, there was no screaming, there was no yelling.
There was no screaming.
He was responding to the operator, right? And even the description by the police officers as to what he appeared like said scared, angry, voice shaking, facial expressions.
Well,
I don't know how that leads to the conclusion that he's under the stress of the event.
If you're shaking, if your voice is shaking and you're upset, then you're under the stress of there's just been a gunpoint robbery. And I believe that when you listen to
What about what your adversary says with regards to the passage of time?
the passage of the time, there was hardly any passage of the time. The only passage of time was enough to pursue the people at a somewhat safe distance. That doesn't reflect any ability to fabricate or to think about the events, the underlying events. I think the shaky voice, I think the voice on the call is shaky, which is exactly what the police officer said. And I absolutely submit, if you're shaky, angry, upset, it's because you're under the stress of the gunpoint robbery that has just occurred.
Is there anything in the record as to exactly how much time elapsed between them leaving and him calling and the 911 call? Is it 5 minutes? Is it 4 minutes?
I don't think it's entirely, there's not absolutely clear, but I would submit it seems like it's something like in the area of 5 minutes. And I would note that when the defendant is arrested or stopped with the police, he's a 3-minute walk away from where the crime scene occurred. This is not omitting the fact that first of all, I don't think it's even clear that he said he recognized him. He said he didn't know the person's name until his girlfriend at some point told him.
I thought the girlfriend had gone to school with him.
Right, but that's not clear that he knew that at the time, but that could have been said to him after the event. Why would that be something that you would put into a 911 call where you're trying to get the police to come help you, to help apprehend perpetrators who you're afraid are not finished with you yet and who you want to be apprehended? He didn't say that he recognized him. He said he'd seen his face around the neighborhood. But those just aren't facts that you would expect to be in a call. Not every fact. This was not, the 911 call is not a place to give a full account of the crime. The key facts were, we were just robbed at gunpoint. There are 3 people. Here's the description. This is the direction they're going in.
If we're going to look at it as your adversary mentions in the totality of the circumstances, maybe taken individually, the time, the fact that he was cool, the fact that he didn't mention the person's name, maybe don't add up to an excited utterance standard. But what if we look at it all together?
I think altogether it absolutely comes up to an excited utterance. None of these things in isolation. Again, I think he did have the nature of this event was traumatic. The gap was just to go follow them. It's not like in the cases where they cite where somebody makes a phone call or gives a gun to the mother or goes home or calls the employer. All they did was said that we're going to go.
Was it a continuous event?
It was a continuous event. It was an absolutely continuous event. And the statements were not made in response to any inquiry. Which also I think is very important in showing it's an excited utterance. All that the operator asked was, what's your emergency? And that's when he elicited all the statements about what happened. It was a gunpoint robbery. There were 3 people. There were no questions that could have given him a chance to mull over what had happened and to think about fabricating. There was absolutely not one indication in this record that would suggest that this person had an opportunity or an inclination to fabricate anything. In the Dawson case, which defendant cites, and in a couple of the cases, declarants were defendants, were the defendants who were charged with the crime, and the court noted that they had a real, it was their statements that were at issue, that they had a real incentive to fabricate. That's not true here. I think this is a pretty classic excited utterance. In addition, there was very strong evidence here of the gunpoint robbery. The defendant was involved in the gunpoint robbery. He dropped, when the police cornered him, he dropped the bag containing the gun that matched the description of the gun that was used. It had the laser attachment. His DNA was on the...
I assume this argument is going to your harmless error?
Well, if anything, yeah, I'm saying that he was convicted after a fair trial.
Thank you.
Okay, thank you. We ask that the judgment be affirmed.
Just a few points, Your Honors. First of all, I just want to reset for 1 second, right? Where hearsay evidence is being offered, the proponent who is offering it has the burden of establishing its admissibility, right? And they had to establish here that this was an excited utterance. Below, their argument was essentially only that that this was a robbery and anybody would be upset, would be unnerved by this.
There's no per se inference or presumption that because you were a victim of a gunpoint robbery that you would be under the excitement of that event.
Correct.
When you make a phone call to 911.
Correct. In fact, there are plenty of cases.
And I think most people would be, but there's no presumption.
Sure, but there are plenty of cases where courts have found hearsay not to meet the excited utterance standard in very violent circumstances, including homicides. Second, with regard to the call, and I do want to emphasize that again, we are arguing it is the totality of these 3 factors I've talked about. With regard to the call itself, the judge below said he is not screaming. I think the voice is quite plainly described as calm and unhurried, but to the extent that respondent is now citing to Officer Roberts' testimony later about shaky testimony, that happened well after the application for the 911 call, which was before trial. They cannot rely on testimony that came in later to establish the evidentiary admissibility. They didn't make that argument below. They did not establish that below. As to the time to think question, I do understand where your honors are coming from. I would note that Ortiz specifically said we were thinking about maneuvering in following these people. I understand that that would be a natural reaction, but our question in determining whether this evidence is admissible is whether he had the opportunity to reflect or fabricate. And I think kind of coming up with a strategic plan for doing so is one factor that we think is deeply relevant to that. And then the last point I'd like to make is, with regard to the question of whether he omitted something, Ortiz's testimony was, and this is 216 and 17 of the record, I was a bit familiar with Joshua. So he knew this person. He did not report that in the call. That is something that this court found in Stewart, 241 83rd 1179 last fall. That was not a 911 call, but it had to do with the admissibility of hearsay under the excited utterance. The omission of identity is a relevant factor that shows this capacity to reflect or fabricate. We're not saying he did fabricate. We're showing that he had the opportunity to do so and was not so excited.
Why would he want to not tell them what he knew about the person's identity? That makes no sense to me.
There are lots of questions in this case. Why would you follow the people who just robbed you? Why was there this delay?
Back.
He didn't mention that
He
his.
wanted the Gucci belt. Thank you.
I was just going to mention the belt and the watch.
Gucci belt, right.
Thank you, Your Honor.
Last case for argument is Thomas Realty v. Chilotes. Whenever you're ready.
Good afternoon, Your Honors. My name is Robert O'Hara, and I'm here for the appellants this afternoon. And we're here to ask that the derivative claims that have been brought in this case by the plaintiff on behalf of the condominium association for breach of fiduciary duty and aiding and abetting breach of fiduciary duty be permitted to be submitted to a jury at trial.
Well, to do that, we would really have to overrule our decisions in Moyle versus Sleppen and Horizon Asset Management versus Duffy, which are not very old. So what has happened that should cause us to overrule those cases, which we really don't like to do?
Well, I wouldn't say that this court would be overruling those cases. I think
Those cases said that a derivative action, a plaintiff in a derivative action doesn't have a right to a jury trial. You're asking us to hold that a plaintiff in a derivative action does have a right to a jury trial. It seems to me that would require overruling those two cases.
Well, in those cases that you're referring to, Your Honor, Horizon Asset and also the Moyle case, those cases held differently than the two prior cases by this department.
Right, but the two prior cases were before the decision by our court that we're not bound by cases interpreting the Seventh Amendment. So that's put us in a very different situation.
Well, I'm not sure about that, Your Honor. I think what happened was, and what I'm arguing for is that you would be reconciling the different outcomes by this court. And so what happened back in '93 and '94 in the Abrams case and the Rocha case, those cases came out definitively in favor of our position here, that a derivative claimant is entitled to a jury trial.
Right, and 20 years later, we decided differently, and now you're asking us to overrule those.
But in those in the subsequent cases, Your Honor, in the Horizon case and in the Moyle case, this court did not specifically overrule those prior cases. It just didn't even mention them. It made no mention of those whatsoever. And in fact, in the subsequent cases, there was no analysis as to the CPLR 4101 requiring.
The only way that we could do that, we would have to mention those cases specifically, or the pattern that follows afterwards, does that also indicate where the law is going?
Well, Your Honor, you mean the pattern after the two cases
that support your position?
No, meaning in Horizon, would we have to have stated specifically that this case overrules the prior cases.
Well, I think it would be helpful if this court did, but I think Your Honor's question is also.
that was my question.
Yeah, I thought you were also asking if subsequently after those decisions, whether the courts have been adhering to those decisions, and I'd say the answer is generally no on that. Most recently.
What is your best case?
Excuse me?
What's your best case to support the jury trial?
Just looking at the plain language of 4101, Your Honor. In the plain language of 4101, the CPLR says, in the following actions, issues of fact shall be tried by a jury. And subsection 1 says, in an action.
My colleague asked you for your best case.
The best case for this, Your Honor, is actually what Judge Cohen has said below, giving his reasons why he believes that this is for a sum certain of money, will resolve the issues. It's not equitable, and we should be looking at, Your Honor, the substance of the claim, the gravamen of the claim. We should not be looking at the equitable source of a derivative action. We should be looking at the claim itself.
Outside of the Abrams and Rocha cases, do you have any other appellate authority?
No other appellate authority, Your Honor, since. It really hasn't come up, actually. The most recent case before our case at the commercial division was Justice Maisley in the Kahn v. Garg case, which came out along the lines that we're suggesting.
But she doesn't govern our choice.
I understand that, Your Honor, but there really hasn't been a lot of case law on this issue. And I would just ask that what would it look like in reading the short decisions that are going in favor of the respondents in this case? There was really no analysis as to the substance of the claims. There was no analysis with respect to the remedy that was being sought. What was only being looked at was essentially just a general statement that in derivative claims are by themselves the proceeding, the action it has
So
its
is your
origin.
argument therefore that this is something, that you're seeking something more than equitable in nature?
We are, Your Honor. This is because think about it for a second.
How are you doing so?
Well, our claims here seek money damages. They're at law, the breach of fiduciary duty and the aiding and abetting. And it would be incongruous if we said, if this were not a derivative claim, if the condo association in the first instance brought these claims against these same defendants seeking the same damages, that the condo association would be entitled to a jury. Now, there's been a mechanism put in place that when the condo association is the bad actor, in this case the defendants, and they refuse to take action on behalf of the association, that the mechanism that's been put in place is just a derivative action. The claims itself are not equitable. Right. It was just equity that created the action. So there shouldn't be a difference between the association bringing the claim in its own right and then a derivative plaintiff bringing those same claims against the same defendants for the same damages, and those claims are not equitable. They're just seeking money damages, which is consistent with CPLR 41011, which says, in an action which a party demands and sets forth facts which would permit a judgment for a sum of money only, you're entitled to damages. There's no exception for derivative claims.
You have time on rebuttal.
Good afternoon, Your Honors. Joseph Dimitrov, Litchfield Cavo, on behalf of the individual respondents. A plaintiff on this appeal asked this court to look into the nature and substance of the relief requested.
What about the argument that if the condo had brought such an action, you would be entitled to a jury trial?
I do not believe so, and that goes in line with the argument that is raised by plaintiff that the nature and substance of the relief, looking at the totality of the circumstances, including the entire course of dealing to determine the appropriate repayment amount under the loan, it is inherently equitable in nature. What they claim to be monetary damages.
It's really money, right?
It is a confused issue as to whether or not they are looking for money. What
you're seeking, what you're defending against is their claim for money.
Correct. In a sense, if I could expound on that, what they're looking for is a repayment of monies that was made on a loan in which the underlying loan is not in dispute. There are loans from the 1990s that were unpaid for 20 years, and when that loan was repaid, a certain amount was voted on by the board in order to do the repayment. Now, what plaintiff is seeking by virtue of this action is a return of the monies as a whole, essentially saying that the repayment of the loan was unequitable.
So would the monies be repaid to the individual cooperators, or would they condo owners, or would they go into some type of operating fund for the condo?
It would go back into the condominium association, but then that would mean that the underlying loan that was repaid is now back into effect.
So does that now give, would that translate into any monies going to the owners, to the condo, to the plaintiff?
Ultimately, no, because if the loan is unpaid by virtue of bringing back the money to the condominium, then that loan that was repaid in 2014 is now unpaid.
So they would not actually be recouping any money.
Correct, because then the loan would still need to be repaid. And ultimately, Your Honors, this issue has been decided by this court in the Sackhoff matter. Ultimately, in Sackhoff, even though the complaint was dismissed for laches, it was brought by the derivatively on behalf of the plaintiff for purported overpayment and compensation to the board for monies that were paid out by the corporation. And this court specifically found that those allegations of overpayment are equitable in nature by virtue of being brought by a derivative suit. There is no rationale brought by plaintiff on appeal as to why this court's longstanding law should be overturned in this case.
Thank you.
Thank you.
Good afternoon. May it please the court, Jillian Costello for the funds respondents. I think that we've hit upon most of the themes already here, and it's been a long day, but I will just simply reiterate what has been effectively raised to plaintiff now in this case, which is nothing has changed since Moyle was decided in 2016 that would warrant this court deviating from its prior precedent. There's been no change in the Constitution, in the CPLR, 4101 was there. That case was a case solely for money damages on the derivative claims. This court ruled that it was not for a jury, that it was an equitable claim. So nothing has changed. It is on all fours the same. The same arguments, in fact, while plaintiff claims that the case itself at this court is cursory, before the court below in its decision made exactly the same arguments that plaintiff is making here. They relied on the Ross case. They relied on the Nassau County case from 1970. The exact same analysis was rejected by this court in 2016, and nothing has changed in the law that would warrant changing that. And nothing further.
If I could just circle back, Your Honors, to what's being sought in this case, and it's clearly, if you look at the complaint, which sets forth the causes of action, is to have a trial on damages, and those damages go to what we will have to prove at trial would be what the amount of the loan was that was taken from that was taken out of the coffers of the association. And
so those monies, so if you were successful, those monies would go back into the coffers of the association, yes?
But they'd still be damages, Your Honor. It wouldn't.
No, but I'm asking, it would go back into the
That's right.
coffers
They
of the
would-
association, so how would that translate to any monies to you?
Well, it would well, if it went back into the association, arguably, then each association member would be entitled to, in theory, its portion of the ownership. So in our case, if we had, if the plaintiff in this case is owned 23% of the condo association, arguably he would be entitled, in theory, to that percentage of ownership.
A percentage, but not $2,000 or $20,000.
No, but Your Honor, I think the issue is much different. In a breach of fiduciary duty claim, we have to prove what our damages are, right? And in this case, also, I think we also ask for punitive damages. And so we're not asking for restitution or disgorgement, which are typically creatures of statute, of statutory violations. Usually, we cited a case, and one of the cases is in there, having to do with an SEC violation, or if there's some other violation per statute that requires or permits the equitable relief of restitution or disgorgement. But typically, this is a damages case, as Justice Cohen found. And the case law that we cited, one of the cases that we cited in the brief, the name escapes me right now, but we said, you just can't change the name of it and try to say it's repayment, it's disgorgement, it's restitution. What this comes down to is there's an amount of damages. It's the amount that was taken from the corporation, and that has to be paid back by the defendants as damages. I don't know where that money is. I don't know if it's in a bank account. I don't know if it's in the individual, the accounts of the funds at issue. We have no idea, and that ultimately does not matter. It's if they were proven to violate their fiduciary duty, that in this case, that the transaction was not fair and equitable under the entire fairness doctrine.
Thank you
then
all.
they would be damages. Thank you, Your Honors.